In 900. Hello, and welcome to the 63rd meeting of the Civil Rights Council. We're joining you from Oakland on Tuesday, June 23rd. We're really sorry about the technical difficulties with the sound. Thank you to the folks who notified us there was a problem. Hopefully it is resolved and everyone can hear us going forward. We're going to start today with a call to order and a roll call. So I'm going to pass it over to Senior Counsel Sadler to take roll.
Chair Candace Cho.
Here.
Councilmember Christian Acevedo.
Here.
Councilmember Indira Cameron Banks.
Present.
Councilmember Denny Chan.
Present.
Councilmember Jonathan Glader.
Present.
Director Kevin Kish.
Present.
Councilmember Yvette Pena.
Present.
And Councilmember Vasudha Tala.
Present. Thank you. We have quorum, and now I will pass it to Director Kish to do a brief welcome.
Oh, great. I thought I was later on the agenda. I will just offer a very brief welcome to all of our council members. It's taken some time for us to organize this actually first meeting of 2026 of this body. And it is a special meeting for a couple reasons, but most importantly, because for the first time in multiple years, we have a full slate of council members. So I would like to extend a special welcome to the council members who were newly appointed in 2026, Councilmember Acevedo, Chair Cho, Council Member Tala, and Councilmember Pena. Thank you for joining us. This body, as many of the people who are joining us today remotely know, is really unique. It has two distinct statutory roles. One is to interpret California civil rights laws through regulation. The other is to convene hearings, to bring attention and focus to civil rights issues affecting Californians. And it is made up of volunteers. This is shocking, but this is the structure. And so I want to thank everyone for your work. And because this is the first time in several years that we have a full slate of council members, I'm really excited to see after today what we're able to accomplish together in the months going forward. So thank you all very much and welcome.
Thank you. And I'm going to ask Chair Cho to introduce herself.
Thank you, Julia and Kevin. I'm Candace Cho. I'm a policymaker and a lawyer. I was born in San Francisco. I'm now based in Los Angeles. I started my career on the federal level as a legislative staffer in the United States Senate. I then worked as an attorney in the executive branch of New York City government, advising the mayor and other city officials and agencies. And I most recently led policy and civic engagement for AAPI Equity Alliance, an LA-based nonprofit serving Asian Americans and Pacific Islanders, and Stop AAPI Hate, the leading center tracking racism against AAPIs nationwide. What brought me to this council was in part the department. In my last role, I had the opportunity to work with Kevin and the team then as an advocate on critical anti-hate initiatives in California, such as California versus Hate and Welcome In, two programs that are administered by the Civil Rights Department. And this gave me a front row seat to seeing the work, to seeing the high caliber of the work, the rigor that this team brings to it, and everyone's commitment to creating a California for all. So I am very excited and honored to be part of this team. Thank you. And I would love to invite any of the other new council members to introduce themselves if they would like.
Sure, I'll go ahead. My name is Vasudha Tala. I'm a partner at Emery, Chelley, Brinkerhoff, Abity, Ward, and Mizell, which is a civil rights law firm that handles a wide range of matters, litigation, ranging from Section 1883 to housing and employment discrimination. I personally live here in Oakland. I've been a California resident now for about 9 years. And prior to this particular role, I worked at the ACLU of Northern California. as well as the Civilian Complaint Review Board in New York and other positions in nonprofit and government settings. I'm really excited to be part of this body. Really excited to work with the staff here and engage on California fair housing and employment laws.
I'm sure I can go next. Good morning, everybody. My name is Christian Acevedo. Come to the council with not a lot of experience directly with civil rights, but informed by a lot of personal experience. Both of my parents were undocumented immigrants from Latin America, an issue that I think is front and center in the United States and California in 2026 with regards to civil rights and people's basic dignity and liberties. Wanting to give back because I think the country gave my family so much. I actually ended up joining the armed forces at the age of 17, right out of high school, during the era of don't ask, don't tell. And as a gay service member, confronting kind of directly head on what discrimination can mean from a very personal perspective. Like so many others, I'm an attorney by trade now. Most recently, I did a long stint as a public defender in Sacramento County, where I saw really directly the impact of the criminal justice system on people's basic liberties once they've already served their sentence and their time, secondary and tertiary impacts that can have on people's basic dignity and liberties. So come to the council with kind of a mix of different experiences, but really excited to see, especially in 2026, knowing that discrimination is alive and well, what the council can do to lead the way and show that so goes California, so goes the nation.
Good morning, everyone. My name is Yvette Pena. I too come to the council both with personal experience dealing with discrimination. I'm a native of Puerto Rico by way of New York City and have lived in California now most of my adult life. I am a retired attorney, but worked on different aspects of employment law, labor law, hate crimes, and housing law. And I'm very excited to tackle this work and help California continue to lead as it has in this important area.
Thank you so much and welcome. And should I go move on to agenda item 3? Okay. This is Councilmember Cho. I encourage everyone speaking today to also identify themselves before speaking for the benefit of any attendees who are listening instead of watching the meeting. I would like to start by acknowledging the Civil Rights Department staff members joining us today. Kevin Kish, Executive Director of the Civil Rights Department, Julia Parrish, Deputy Director of the Legislation, Regulation, and Policy Division, Rachel Langston, Assistant Chief Counsel of Legislative and Regulatory Affairs, and Mariel Block, Suj Lee, and Ali Sadler, Senior Counsels. I would also like to thank everyone who is attending, either in person today or virtually. We look forward to your participation throughout today's meetings. This meeting is being webcast live via Zoom video conference. Thank you everyone for your patience with technical difficulties. And the video of this meeting will also be available afterwards on the Civil Rights Council's website at https://calcivilrights.ca.gov/Civil Rights Council/ and the Civil Rights Department's YouTube channel. Please subscribe. We also have closed captioning available for participants, which you can find at the bottom of the Zoom bar feature. If you are having difficulty accessing closed caption, you can send an email to the administrator to resolve the issue at council@civilrights.ca.gov. Members of the public joining remotely may have noticed that you are currently muted and your video is disabled at this time. Please note that the Q&A and chat functions are also disabled. However, please be advised that there will be opportunities for public comment and participation throughout today's meeting. At the end of each agenda item, we will ask if there is any public comment. And in the interest of time, we will limit comments to 3 minutes each. An attendee may comment no more than 1 time per each agenda item. We also ask that comments address a specific agenda item. If your comment does not address a specific agenda item, we request that you share your comment at the end of the meeting. Finally, if you feel comfortable doing so, we suggest that you mention your name before your comment, but this is not required. We have a number of ways for you to provide input and comments. First, you can email the council at council@calcivilrights.ca.gov. You will be checking this email account throughout the meeting, and your comments will be read aloud or summarized and considered by the council members. Second, if you would like to speak directly rather than through an email, please click raised hand in Zoom or press *9 if you have called in. If you would like to rename yourself in the Zoom list of participants, you can find yourself on the list and click rename and the list of options next to your name. And I will pass it back to Julia.
Thank you so much. This is Deputy Director Julia Parrish speaking. We're going to move to agenda item 4, review of the agenda. The agenda and meeting materials can be accessed at the council's website at www.calcivilrights.ca.gov/Civil Rights Council /. The agenda includes approval of the minutes of the last meeting on October 6th, 2025, a message from our new chair, Candace Cho, a presentation on workplace job protected leave entitlements, council member reports and council acknowledgements, a report from the Civil Rights Department, a presentation on subcommittee responsibility and time commitments, and subcommittee updates, assignments, and creations. I will move to approve the next agenda item, which is approval of the minutes. As I mentioned, and as we know, this is the first meeting we've had with several new council members. So when we vote on the minutes from a previous meeting, council members should feel free to abstain if they would like to. So the meeting minutes from October 6th can be found as attachment A. Do we have any council member comments or edits regarding the minutes from our last meeting? Seeing none. Do we have any comments from the public in person regarding the minutes from the last meeting? No comments in person. Do we have any remote public comment?
No.
No remote public comments. Can we have a motion to approve the minutes?
So moved.
Do we have a second?
Second.
Great. Ali, can you please call roll?
Yes. Chair Cho,
Abstain.
Councilmember Acevedo,
Abstain.
Councilmember Cameron Banks.
Yes.
Councilmember Chan,
Aye.
Councilmember Glader,
Aye.
Councilmember Pena,
Abstain.
Councilmember Tala. Abstain.
Great. Thank you so much. We have the members who are present have voted to approve the minutes. So the minutes are approved. And I will pass it back to Chair Johnson.
Thank you, Julia. This is Councilmember Cho. I want to give a brief message because it's our first meeting as a full slate in a couple of years and the first meeting for the 4 new members. I promise not to do this every meeting. Thank you to Governor Newsom for the opportunity to serve my home state and to the department staff and my fellow council members for their very warm welcome. I would like to extend that welcome back to all of you, especially my fellow new members. And for the 4 of us who are new, today is the first public meeting for us, as you've heard, and some of us are even meeting each other for the first time. And since the 7 of us are at the start of our time working together, I will take the prerogative as chair to share 3 things that are top of mind. First, to my fellow council members, as some of us already know and others of us are already learning, the council is a little unusual for a public body, or to quote Kevin, really unique. We are 7 volunteers. We live all over the state. We're appointed by the governor. We're confirmed by the Senate, housed within a state department, authorized to issue substantive rules, implementing civil rights laws. And we do this work in compliance with public meeting laws, which is to say during public meetings like today's, and as we'll learn later in this meeting, in subcommittees of 1 to 2 people. We can't just reply all to an email and talk to each other that way, or pick up the phone and call each other to discuss council business. So some of you, like me, might be wondering, well, how can I contribute most effectively in this unique setting? And as chair, I see as my primary responsibility to facilitate our collaboration in this somewhat unusual context. In other words, to create a container for decision-making and an environment where we can all do our best work as equals. Or as the council member handbook puts it, and this is probably the first and last time I'll quote the handbook during a meeting, quote, "The power of the council is vested in the council itself and not with any individual council member," end quote, and that includes the chair. Quote, "Council members shall recognize the equal role and responsibilities of all council members," end quote. So my door is always open to all of you, to your ideas. For example, if you have agenda items for meetings or ideas for guest speakers, and to your feedback. For example, maybe you're hearing something from your networks about how well our civil rights laws are working or not in California. I am excited to draw from everyone's very deep well of expertise, experience, skills, and relationships, and to continue the culture of collegiality and consensus in which this council has traditionally operated, and figure out how we can row together. Second, to the department, I want to thank you for the support, especially with the new members in onboarding us, in shepherding us through the confirmation process, in preparing us for today's public meeting, in troubleshooting on the fly. I know that we're already adding to your very full plates, and we have yet to even dig into a rulemaking. The department's mission, as we all know, is to protect California from illegal discrimination, hate violence, and human trafficking. And this council is one of the tools that the department has to achieve the mission. And so my question for the department, which I think has been shared by other council members, past and present, is how can this council be a force multiplier? I invite guidance from this department on how this group can be a value add to the department as it pursues a mission that we all share, especially today, as we discuss at this meeting what work we want to do together in subcommittees, but also every day. And third and finally, to the members of the public joining us in person or virtually or watching this recording after the fact, I've spent most of my career working for the government, first in Congress, then for New York City and Los Angeles. And I know from my work in my life that what the government does really matters. And that includes what this council does and will do. And as chair, I take seriously the fact that the council is a public body, a part of the state government that serves and represents all of California, that rulemaking is a public process, one in which the council benefits from hearing a diversity of perspectives from a wide range of people and groups, and that the work that we do is not an academic exercise. The stakes are very high. There are people's personal health, their safety, their livelihood, or as I've heard Kevin, as Director Kish has said, people often come to us on their worst days, and it's our job to make sure to do everything we can to help them get support. The work we do matters now more than ever, given the political times that we're living in. And no matter what is happening across the country, I want to make sure that everyone is welcome in this space. You are welcome in this space, and we will do our best to make it accessible to you. And I invite you to participate in it. So thank you for joining us. And speaking of participation, we've come to the end of this agenda item. And so there is an opportunity to comment. Do we have any council member comments? Hearing none. Do we have any comments from the public in person?
About any of the agenda items, is other question.
About this agenda item? Do we have any remote public comments?
Yes, Eric, you can speak.
Hi, good morning. Can you hear me?
Yes.
Okay, great. Good morning, Director Kish and Chair, is it Choi? I'm probably saying it wrong. I apologize. And council members, my name is Eric Anthony Devison. I'm a Doctor of Public Administration student and a county commissioner and a resident of Riverside County. So first I wanted to welcome the new chair and council members. And I wanted to explicitly commend Councilmember Acevedo for leading with such a profound vulnerability regarding his military service during the Don't Ask, Don't Tell hearing. That lived experience that he brought directly into this governance space is really what I came here and really what represents the truth of California needs. So I really appreciate that. As a fellow public servant on volunteer governance bodies, I know the immense dedication it takes to step into these roles. So thank you all for your commitment. And because your positions are, I believe I heard you say they're appointed by the governor and confirmed by the state senate. So you all carry a powerful mandate to represent the highest standards of equity and public trust for all Californians. So your volunteer time is incredibly valuable and the public's assets is vital. So which is why the administrative execution of this inaugural 2026 meeting is so concerning. A 20-minute delay with no audio and zero technical direction from remote participant creates an immediate exclusionary barrier. So for working class constituents, administrative silence means being locked out of the room. So the operational infrastructure must match the weight of your gubernatorial appointments. So as you begin crafting codes, regulations, and policy recommendations, please remember that true equity cannot just be an agenda item. It must be reflected in how we respect the public's time and how seamlessly our constituents can access this space. So let's set the standard worthy to your mandate for the rest of the 2026. Thank you, and sorry to kind of complain.
Thank you for your comment. Are there any other remote public comments?
None.
I think is that where we're moving on to agenda item number 7? Okay.
Yeah, perfect. Yeah, none.
None? Okay. Okay, agenda item number 7. We have a presentation today. As Director Kish mentioned, one function of the council is to host informational hearings and presentations. This training is timely because the council is currently drafting regulations surrounding new and existing leave entitlements. And as I mentioned, the door is open to my fellow council members for your ideas around future experts or topics. Council members and the public will have an opportunity to comment after the presentation. Right now, I would like to welcome and invite Liz Morris, the co-director of the Center for Work-Life Law, where she leads the center's legal team to advance gender and racial justice in the workplace. Liz's advocacy builds legal rights for pregnant and lactating people, parents, and family caregivers struggling to take care of their loved ones while making ends meet. Liz is a nationally recognized expert in the employment laws intersecting gender, reproductive health, and family care. Liz's writing has been featured in the New York Times, LA Times, Harvard Business Review, and Slate. She speaks frequently at conferences, has appeared on NPR and television, and is regularly quoted by media ranging from the Washington Post and PBS NewsHour to Working Mother and Elle. Liz also co-authored Work-Life Law's 2019 report, Exposed: Discrimination Against Breastfeeding Workers, which provided the rallying cry for the 2022 Pump for Nursing Mothers Act. This law gives lactation rights at work to nursing parents nationwide, was based on model legislation drafted by Liz and her colleagues. In the first part of her career, Liz represented working people in class action lawsuits challenging abusive employment practices and unions in the labor movement. Liz co-taught advanced employment law for 6 years at the University of California Law, San Francisco. She is a graduate of Claremont McKenna College and received her JD from Stanford Law School. Thank you so much for joining us today, Liz, and welcome.
Thank you. Thank you for having me. It's wonderful to be here, and congratulations to those of you who are new to the council. Just realize that this was a volunteer position, so that's really commendable. Thank you for your service. As a number of people have said, these are really important times. I can't imagine a more important time in recent history to join a body like this one, given what's happening at the federal level. So I'm thrilled to be here today to talk with you all and to meet you all about employment rights for life's big moments. I had a lengthy introduction, so I won't say more except for Work-Life Law's mission, which is in line with the mission of your body, and that is to advance gender and racial equity in the workplace and in education by building legal protections for family caregivers, for pregnant people. Our sort of goal is to make sure that people can take care of their health, can take care of their loved ones, can have healthy pregnancies, make reproductive choices that make sense for them without losing their jobs, maintaining their economic security. So this is a perfect topic for me to be speaking about with all of you today. So I'm going to start with just two. I'll use the word hypotheticals because from what I gather, most of you at least are lawyers, but really these stories that I'm going to share aren't based on a single individual, but are based on what we hear every day on Work Life Laws Free Legal Helpline, where we provide assistance to hundreds of workers every year. And so I'll start with a pregnancy example. Rosa's 12 weeks pregnant. She has to wake up every morning at 3 a.m. for her job picking strawberries in the field. Rosa has had a very difficult start to her pregnancy between morning sickness, exhaustion, and the extreme physical demands of agricultural work. Rosa is also very worried about the impact on her pregnancy of the pesticides that are sprayed on the crops, as they smell strongly and there are rumors that they're dangerous. Rosa believes she has no option but to keep working that job so that she can pay her bills now and be in a financially secure position when her baby arrives. So I'm not going to get into analyzing Rosa's situation right now, but just want this in our minds as we talk about all of the laws today related to leave and accommodation that would apply in Rosa's situation. And then we'll return to it at the end and see what applies. Okay. And so similarly with family caregiving, here's another scenario. Grace works at a call center. Her father, who has dementia, recently got lost after wandering outside when Grace's mother was in the shower. Grace's family decides that her parents will move in with her. This will allow Grace to support her 72-year-old mother, as caring for dad is an intense around-the-clock job. When her mom gets the flu, Grace uses up her state-mandated sick days. The following month, Grace is late on 2 occasions to work, in both instances because her father was experiencing a dementia-related health issue. Dad has a medical appointment coming up when big health decisions will have to be made. Grace asks to take off work early to attend the appointment. Her boss responds that Grace can't have any more time off and is going to have to decide whether she wants to take care of her parents or keep her job. So again, this is the type of thing that we hear coming up all the time. And I'm sure many of you all here and on the line remotely have experienced these kinds of things, heard about these kinds of things in your families and communities. And so we're going to talk about the laws that were designed to address these kinds of scenarios. We'll start with the legal rights to take time off for life's big moments. We'll start with pregnancy, childbirth, and baby bonding. And then we'll talk about serious medical conditions, the need to take time off for one's own health or for caregiving for a family member or a loved one who has a serious medical condition. We'll also touch on bereavement leave and reproductive loss leave, which are also provided by the laws interpreted by your body. And then we'll touch on some related rights as well, including discrimination and also reasonable accommodations for pregnancy and childbirth and related conditions. And then just briefly at the end, I'll share a little bit more about Work-Life Laws Free services, including that helpline in case anybody listening in could benefit from those. Okay. So it's a lot of content. There are a lot of civil rights protections in California, thankfully. So let's jump in with time off and paid leave. When we're talking about time off and paid leave, it's really important to think about the difference between paid leave on the one hand and job protection on the other hand. And the reason why it's important to think about these two things separately is because they provide different protections. They have different eligibility criteria. They run for different durations of time, and they are the rights or the protections are provided by different laws. So when people say leave, they sort of think about pay and job protection in the same bucket, but actually when we're trying to understand the law, it's helpful to think about them separately. So when I say paid leave, we're talking about partial pay while an employee is working less or not working. And so income replacement, how are you going to pay the bills? And then job protection protects the employee's job, giving them the right to return to the same or a comparable position. So when I am done taking the leave, I have a job to actually return to. Paid leave derives from the paid family leave, or PFL, and state disability insurance, or SDI program. Whereas job protection, actually, I think there's 5 or maybe 6 laws here that can provide this right depending on the person's context. So the California Family Rights Act, which is administered by CRD, or CIFRA, as it's commonly referred to. The Pregnancy Disability Law, also administered by the agency, or PDL. The Fair Employment and Housing Act, also administered by the agency, or FEHA. And then I've also listed 2 federal laws here, the Family and Medical Leave Act, or the FMLA. And the reason I'm including that here is I'm going to just briefly touch on it because I think a lot of people, when they're understanding what their legal rights are, or for employers, what their obligations are, think, well, what about the FMLA? Because that's sort of what everyone hears about. So we'll see how that interacts with these state protections. And then also the Pregnant Workers Fairness Act, which is a relatively new federal protection that in some situations actually provides more rights than what people have under California law. And so I think it's important to explain what those additional protections are that the regulations in California do not provide. And then in terms of paid leave, a worker who needs paid leave applies with the California Employment Development Department, or the EDD. It's a state administered benefit. And then with job protection, that's requested from the employer, whether it's HR or someone's direct supervisor, you work that out directly with the employer. Okay, so starting with job protection for pregnancy and childbirth. I'm going to start with pregnancy and childbirth. I'm going to talk about the job protection piece, and then I'm going to talk about the income replacement piece. And then I'm going to do the same thing for baby bonding leave, and then I'm going to do the same thing, the job protection and then the pay for serious health conditions. Okay, so starting with job protection for pregnancy and childbirth. The relevant law here is called Pregnancy Disability Leave Law. It's found at California Government Code 12945. It applies to employers with 5 or more employees and requires them to provide time off when the employee is unable to work because of pregnancy or a childbirth or related condition. It provides up to 4 months of job protected leave, as well as continued health insurance benefits. So whatever the employer would have been providing, if the employee had been working during that time, they need to continue providing that. And as I'm sure is pretty obvious, that's extremely important for people who are pregnant or having a baby. This leave can be taken actually at any point in pregnancy. It can be it's called pregnancy disability leave, but it can be taken at any point in pregnancy. So it could be taken for somebody who needs time off for prenatal care appointment. It could be taken by somebody who needs to avoid hazardous work. We'll look at more of the situations when people can take it in a moment, but it can be taken at any point during pregnancy or postpartum. It can also be taken intermittently, meaning not all in a single 4-month chunk, which makes sense. Because it's for somebody's health needs. And so what somebody may need, could be of different duration, including like down to, I need 2 hours off to go to the doctor for my prenatal check. Employees must be returned to the same or a substantially similar job at the end of the leave. And this, of course, is the key piece of the protection. Oh, what happened? Okay, that was not as painful as I thought it was going to be. All right. Important to know that there's additional time beyond the 4 months that may be available absent undue hardship. And by absent undue hardship, I mean so long as there's not a very significant difficulty or expense for the employer, an employee who needs time off for pregnancy or childbirth or related condition may be able to get more than 4 months off. And there's two ways that may be available to them. First, under FEHA's disability accommodation provision, which is at California Government Code 12940M. If the person has a disability related to their pregnancy, then just like anybody else who could seek an accommodation for their disability, they could seek it for their pregnancy. Pregnancy and leave can be a form of accommodation under FEHA. Pregnancy alone does not give somebody a right to seek an accommodation for a disability, but oftentimes people will have a disability that's exacerbated pregnancy or that's developed as a result of pregnancy, and they could access additional time under FEHA in that way. Additionally, that federal law I mentioned earlier, the Pregnant Workers Fairness Act, also provides leave as a reasonable accommodation for pregnancy and childbirth. And so it could exceed the 4 months, again, so long as there's no undue hardship to the employer in providing that. I alluded to this earlier, but pregnancy disability leave is a misnomer, and that is because leave can be taken for many reasons, including for reasons that do not constitute a disability in the way that we normally think about the meaning of that word under the law. So it can be taken for appointments for pregnancy or childbirth. Somebody who has just sort of a standard routine pregnancy can take time off to go to the doctor or to go to their healthcare provider. Also, it can be taken for avoiding hazardous work. So for example, Rosa from our scenario was going to be exposed to pesticides. And so this kind of leave could be available to someone in a situation like that so that they can protect the health of their pregnancy. Recovery from childbirth is also available under this PDL law, pregnancy disability leave law. Typically, if there's no complications, somebody who gives birth will have either 6 weeks if they have a vaginal delivery or 8 weeks if they have a cesarean section. And it could be longer if there's some sort of complication. Time off under PDL is also available for abortion and pregnancy loss, as well as pregnancy-related conditions like morning sickness, gestational diabetes, prenatal or perinatal depression or anxiety, so during pregnancy or after pregnancy. Any of these reasons, any of these conditions could cause somebody, depending on their job, to need time off. That would be available under the pregnancy disability leave law. Okay, so how can a worker receive income when taking time off for pregnancy, childbirth, and related medical conditions? So now we're sort of shifting gears. We've just been talking about the job protection, and now we're going to talk about the income. How can someone get paid when they are off because of their health conditions related to pregnancy? The answer is state disability insurance, or SDI. It provides workers with 70 or 90% of their regular weekly wages, depending on what their income is, for up to 52 weeks. So low wage workers receive 90% and higher income earners receive 70% of their regular weekly wages. And a worker is considered disabled and thus eligible for SDI if the worker's healthcare provider recommends that they not do their normal work. And you can see I put disabled in quotation marks because, again, it has a different definition as compared to what we think of under FEHA or under the ADA for a condition that constitutes a disability. This kind of SDI can be taken at any point in pregnancy. So again, think back to Rosa, who needs to avoid hazardous work. As early as a positive pregnancy test, Rosa could apply for and receive SDI if her doctor recommends that she avoid her normal work. And the worker applies with the Employment Development Department, or EDD, for this benefit. Almost all California employees pay into the SDI program, and it's completely worker funded. So almost all employees in California have regular paycheck deductions. It'll say CASDI usually, or SDI, something like that on the paycheck. And so 100% of this fund is actually funded by us, by workers. not by me because I work at the University of California, and maybe not some people who are public sector workers, but most workers, or I should say most employees, non-independent contractors or people who are classified as such, pay into this system. Okay, so now we're going to talk about baby bonding. We're going to leave behind what people need, the time off that people need for their health, their pregnancies, health, their and talk about time with the baby, actually caretaking, not related to the health needs of the birth parent. Okay, so the California Family Rights Act, or CFRA, provides an additional 12 weeks of baby bonding and caregiving during the first year of the child's life, or the first year the child is in the home for adoptive and foster youth. And the reason that I say additional 12 weeks is that this is in addition to the 4 months that somebody, not everyone needs an entire 4 months, of course, but the time that somebody could take under PDL, which could go up to 4 months. In addition, they have this 12 weeks for the purpose of caring for their child. There are stricter eligibility requirements, though, than PDL. So under CFRA, eligible caregivers work for an employer with 5 or more employees, so that's the same, must have worked for the employer for more than 12 months in the last 7 years, and must have worked for the employer at least 1,250 hours in the 12 months prior to the leave. And that comes out to about 25 hours per week. So as you can imagine, this knocks out a not insignificant portion of people from getting these benefits. And it's typically, it's more likely to be people who work part-time, who work multiple jobs, and so more likely to be low-wage workers who are getting knocked out of this protection. The good news is during this period, health benefits still must be maintained, and this leave can be taken in 2-week increments or even shorter periods of time on 2 separate occasions. And non-birth parents are equally eligible, and that makes sense, of course, because the purpose of the leave is to take care of the new baby, to bond with the new child. Okay, now shifting to paid leave. For baby bonding. So taking care of the child, how do you get paid? The answer is paid family leave, or PFL, which provides partial pay, 70 or 90% again, for 8 weeks of time off of work to care for the baby. That is also administered by the Employment Development Department, or EDD. It's also funded, just like SDI, out of the State Disability Insurance Fund, which again means that almost all California employees are eligible. And non-birth parents are eligible to collect this 8 weeks of income replacement when they're off of work to bond with the baby. Intermittent leave is available as well. Okay, so that was a lot of numbers and purposes and eligibility criteria. So what I would like to do now is share a visual for those of us who can learn in that way of a birth parent's experience collecting all of these benefits. Okay, so this is a typical, this experience reflects a typical pregnancy and postpartum leave for somebody who works, I said, an office job with no health complications. And by office job, I just mean that they do not have a physically demanding job. They do not have a dangerous job. They perhaps sit at a desk and they can sit and stand as they need to and go to the bathroom, right? Like they just have a job that is easier to do when you're pregnant, and they have no health complications. So, you know, they're not very ill and needing to go to the hospital, those kinds of things. Okay, so in that situation, here's what things usually look like. Along the top, we have time off, and along the bottom, we have pay. So for job protection on the top, we have pregnancy disability leave, which is typically in this office job context, given 4 weeks prior to delivery or 4 weeks before somebody's due date, and then 6 to 8 weeks, again, depending on how the baby is delivered, postpartum. During that entire time, which could be 10 or 12 weeks, state disability insurance provides income replacement for that entire period of postpartum disability. And then after the person is fully recovered from childbirth, the baby bonding leave can begin. And they are entitled to 12 weeks of baby bonding leave when they're eligible for CIFRA. So long as they meet those requirements, like they have worked 1,250 hours in the previous year. Of that 12 weeks that people's jobs are protected and their health insurance benefits are being continued, you can see on the bottom that 8 of those weeks they're eligible for paid family leave. 12 minus 8 is 4. So that means that there are 4 weeks that are unpaid. And for low wage workers, that typically means that they go back to work. Okay. Now we're going to shift gears a little bit and talk about family and medical needs beyond pregnancy and birth and adoption. So CIFRA provides up to 12 weeks of job protected leave with continued health insurance benefits for the employee's own serious health condition or to care for a family member who has a serious health condition. So what is a serious health condition? A broad range of conditions, things like dementia, cancer, diabetes, heart attack, stroke, mental health disorders, asthma, other conditions that are chronic or require ongoing medical care. So it's not something, like your common cough or cold, but it has to be a little more serious than that, but it's a broad range of conditions that people can take this 12 weeks off for their own health or to care for a family member who has one of these conditions. Okay, what about income replacement during that time off? State disability insurance, SDI, again, provides income replacement for up to 52 weeks when an employee is unable to do their normal work due to their own health condition. So that same benefit that could apply to somebody who has a pregnancy-related condition could apply to somebody who has any serious health condition. Likewise, paid family leave or PFL provides income replacement for up to 8 weeks when the employee is off of work caring for a serious ill family member. So same programs. Family caregiving leave. I think for most people, it's sort of intuitive that, if I had a heart attack, I would get time off, and that makes sense. I think, what does it mean to, when do I have a right to take time off to care for a family member is a little less obvious to people, I think. So I just want to touch a bit more on that. So caregiving leave under CIFRA is available for employees who are caring for their child, parent, grandparent, grandchild, sibling, spouse, domestic partner, or designated person who has a serious health condition. A designated person is a person with whom you have a close, or whom the employee has a close or a family-like relationship. There is job protection available for the designated person leave now. And in July 2028, there will be paid leave available. So this is protection that allows people to take time off for chosen family. It's very important for immigrant communities, people who may not be living in a community with family that's related by blood or by law. It is also very important to LGBTQ plus communities and families. And the person, employees can designate one person per year, and they can designate the person at the time that they're requesting the leave. And this can also be taken intermittently, including on a reduced work schedule when it's medically necessary. Again, that makes sense when we're talking about what somebody's health dictates. It can be taken intermittently. Okay, what type of care is actually eligible for leave? It can include assistance with basic medical, hygienic, nutritional, or safety needs, time off for providing transportation, physical care, and psychological comfort. So here's some examples of things that would, activities that would entitle somebody to take time off to provide care for a family member with a serious health condition. Going with a family member to medical appointments or driving them there to their appointments. Providing psychological comfort and reassurance to a patient or a family member who's undergoing treatment. Grocery shopping or cooking for a family member who's recovering from surgery, helping a family member to eat or to bathe, these activities of daily living, arranging for medical treatment or nursing care, filling in for another caregiver. My mind is going to the hypothetical. I don't remember the name that I gave that person, but the second hypothetical about family caregiving. Okay. So want to also touch on two more leave protections that are administered by CRD, starting with bereavement leave, which is Government Code 12945.7. And that also applies to employers with 5 or more employees. That's the trend. Eligible employees in this context have to have been employed for at least 30 days. And they have a right to up to 5 days off of work unpaid within 3 months of the death of a family member. And a family member is defined as a spouse, a child, a parent, a sibling, a grandchild, a domestic partner, or a parent-in-law. There is a bill moving right now, SB 1149, that would add designated person. So perhaps we'll see that coming soon. The employee must be permitted during this time to use any accrued PTO if they have any in the bank. If not, then it's unpaid. The last leave protection is reproductive loss leave, and that's at Government Code 12945.6. It has the same eligibility criteria and rules as bereavement leave. 5 or more employees must be able to use your PTO, but it provides time off for any of these circumstances or events: miscarriage, stillbirth, failed adoption, failed surrogacy, and unsuccessful assisted reproduction. So for example, failed IVF. And it's available for the employee's own loss, as well as to an employee who would have been the parent of the child born or adopted. With all of these principles or types of leave that we've been talking about, whether it's for somebody's own pregnancy or to take care of a new child or for bereavement, all of the leaves we've been talking about, there are principles of non-interference and non-retaliation for requesting or using the job protected leave. So first of all, employers can't interfere with an employee's ability to take leave, including discouraging it. So I think it's probably obvious that if I am an employee and I ask if I can take leave and my employer tells me no, and I have a right to receive it, that would be illegal. But beyond that, interfering with somebody's ability to take leave, discouraging them from taking leave, could also be a violation of the civil rights laws. So if I ask my employer, I need this leave to take care of my father to go to his medical appointment, and they say, oh, well, I guess, yeah, you do have a right to that, but, oh gosh, I don't know what that's going to do for your promotion, and then I decide not to take the leave. My rights have still been violated because I was deterred by my employer to taking my leave. After the leave, you have to be reinstated to the same or a substantially similar position. And substantially similar means with regard to pay and benefits, very importantly, to location, to schedule. So especially for caregivers, and new parents, one form of retaliation could be changing somebody's schedule. That could actually push people out of their jobs. Schedule has to be the same. Status, opportunities for promotion, seniority. So really a comparable job. Employees cannot be punished for taking leave, including in performance evaluations. So the fact that you took time off can't be a ding against you and well, you didn't meet all your metrics. Well, I wasn't here. Performance metrics similarly have to be adjusted to take into account the fact that somebody has taken leave, and not adjusting that could be discriminatory or retaliatory. Obviously, harassment and denial of promotion or other opportunities could be retaliatory. Just a quick note on paid sick days, since that is a right that people have in California. All California employees are entitled to 40 hours or 5 days of paid sick leave annually provided by their employer. That's not administered by CRD. It's part of the Labor Code Section 246, but obviously interacts here, so helpful to know about. And that's a good option for very brief periods of time off. Obviously, 5 days a year is not much. Common cough or cold, something that CFRA doesn't cover, or people who aren't eligible for longer periods of leave are often still eligible for this. What about the FMLA? People often say, what about the FMLA? Or people who call our helpline say, my employer said that the FMLA does XYZ. So always helpful to know what the FMLA is. It's a federal law that provides up to 12 weeks of job protected leave for pregnancy, childbirth, baby bonding, and caring for a serious or for a family member with a serious medical condition, serious health condition. So the FMLA does run concurrently with PDL, pregnancy disability leave, and CFRA in most cases, but it doesn't provide any greater rights. So this is an example where the federal law, and this is typically what we see when it comes to civil rights protections, is that the federal law is not as protective as California state law. It has stricter eligibility requirements, so that means far fewer people are eligible for it. It gives fewer protections. So for example, it has a more narrow definition of family that includes spouse, parent, child, and that's it. So practically speaking, California employers and workers can look first to California law and sort of trying to understand, what do I have a right to receive, or what is my obligation to provide in this context? Okay. Want to, I feel like I should pause for questions. Maybe I should keep going. What do you, okay, keep going. Yeah, okay. So this is a lot of listening to my voice, but I will keep going. Okay, so we are going to talk about related rights, first discrimination, and then reasonable accommodations. These things often crop up when we're talking about leave and caregiving and pregnancy and all of that. Okay, so discrimination based on pregnancy, childbirth, and related medical conditions is sex discrimination under FEHA. Is sex discrimination, which of course is illegal under FEHA, includes discrimination on the basis of pregnancy, childbirth, lactation, and related medical conditions. Discrimination based on reproductive health decision-making is also prohibited. So the decision to have an abortion, the decision not to, we've received calls on our helpline from people in both situations who have, been penalized at work for their decisions. That is also illegal under California law. Another related right that would love for you all to know about is the right to receive reasonable accommodations for pregnancy, childbirth, lactation, and related needs. So reasonable accommodations in this context are changes to when, where, or how the job is done to meet somebody's health needs, to reduce their pain, to minimize risk. State and federal law give a right to reasonable accommodations to these workplace changes for pregnancy, childbirth, lactation, miscarriage, pregnancy loss and abortion, fertility, IVF, and other similar conditions and circumstances. So under California law, that right to accommodation for pregnancy is provided by the Fair Employment and Housing Act at California Government Code 12945. So that's FEHA, and it applies to 5 or more employees. Under federal law, we have the Pregnant Workers Fairness Act, and that applies to employers that have 15 or more employees. And they must provide accommodations for pregnancy unless there would be an undue hardship, which is a significant difficulty or expense. So looking at this, you could be thinking, well, California law applies to more people, it has a smaller employee threshold, there's no undue hardship exemption. This seems like a more protective law. And in those two regards, that is true, it is. And I'm going to show a slide in a couple of minutes where California regulations do not provide as great of protections as the federal law. Okay, but before I do that, I just want to talk about some examples of reasonable accommodations so we know what we're, even talking about here. Okay, additional breaks to check blood sugar and to eat. So if somebody has gestational diabetes, they may need permission to do that at work. Moving their workstation closer to the bathroom. So that could be for somebody who has bladder control issues or nausea, both of which are very common in pregnancy. A temporary transfer to an alternate position to avoid exposure to toxins during pregnancy or while nursing. So things like pesticide, dry cleaning chemicals can get into breast milk or can impact the pregnancy health. Permission to work from home to avoid viral exposure risk or painful commute could both come up. There can be other reasons why people need to work from home during pregnancy. Excusal from night shifts or mandatory overtime may be available, perhaps for somebody who's dealing with extreme fatigue or for avoiding risk due to not sleeping at night. Breaks in private non-bathroom space to pump breast milk or to breastfeed could be a reasonable accommodation for people who are postpartum, who are breastfeeding. And I just want to note that that right, the break time and space for pumping milk, is also provided by the California Labor Code 1030 to 34, as well as the Federal Pump Act. Time off or leave beyond that 4 months when PDL, pregnancy disability leave under California law, has been exhausted could be available under federal law, as I mentioned earlier. So here are the ways where the federal regulations may offer more protections than the California regulations. And for those of you who don't have a background in employment law, this is like really, employment lawyers are so used to being like, I don't even need to know about the federal law because all that, applies to my client, or my client's obligations or my client's rights are state law. But in this context, that's not true, because under the Federal Pregnant Workers Fairness Act, employers must provide accommodation, even if it requires temporarily waiving essential job functions. So under California law, employers do not have to make an accommodation if it would require excusing the employee from a sort of a central job duty. That is not true under the federal law. Employers may have an obligation to excuse temporarily during the pregnancy one of those essential job functions. Also under federal law, accommodation requests do not have to be on the advice of a healthcare provider, as they do in California. There are strict limits also on employer medical certification requests. So one of the barriers that we often see is, somebody will go and say, I need to sit down on a stool because my back hurts while I'm checking out customers at the cash register. And the employer will say, well, you need to go get a note from your doctor. And that is a major barrier, especially because people's needs during pregnancy are changing, and that can cost money. It's hard to get an appointment. You all have tried to get medical care, so you know what I'm talking about. And the federal law really limits when medical documentation can be requested and how much medical documentation can be requested. Also under federal law, there's certain predictable assessments that the regulations say will virtually always not impose an undue hardship, and they must be provided without medical documentation, which means these four situations that I'm going to show you. Can I sit down on the chair? Yes, tomorrow, or yes, right now. No medical notes, no like, oh gosh, it's going to be really, difficult or expensive. In almost all cases, the employer has to provide it and provide it without delay. And that includes allowing an employee to carry water and to drink as needed, allowing additional restroom breaks, allowing an employee to sit or stand as needed, and allowing breaks to eat and drink as needed. All very important for folks during pregnancy. Okay. Oh. Okay. Just a few more slides. Rights of undocumented workers, as a few people have said, really important to be aware of the rights of undocumented folks right now. All workers are protected by the anti-discrimination and leave laws that are administered by CRD, regardless of immigration status. Also, it is illegal to retaliate against somebody using their immigration status as a weapon against them because they've exercised these rights, complained about not getting these rights, those types of things. In addition, undocumented workers are eligible for paid leave when they pay into the SDI fund. As I mentioned earlier, most employees in California do pay into that SDI fund through weekly paycheck deductions. So anyone who paid in is eligible to collect from the insurance pool that they have funded. All right, going back to these real world examples. Rosa's 12 weeks pregnant. She has to wake up every morning at 3 a.m. for her job picking strawberries in the field. Rosa's had a very difficult start to her pregnancy between morning sickness, exhaustion, and the extreme physical demands of agricultural work. Rosa's also very worried about the impact on her pregnancy of the pesticides that are sprayed on the crops, as they smell strongly and there are rumors that they are dangerous. Rosa believes she has no option but to keep working her job so that she can pay her bills now and be in a financially secure position when her baby arrives. So I hope after everything that we've talked about that you agree that actually Rosa does have other options, which is wonderful. And first of all, she could ask for an accommodation and keep doing work. That would keep her at 100% of her income. So maybe there's another crop she could be transferred to where there are no pesticides and there's maybe less physical like bending, or there's less exertion, or it's at a different time of day, or maybe there's an entirely different job like packing produce instead of harvesting it that Rosa could do. If none of those things are options, though, leave is available to Rosa as we now know, as well as SDI. So let's see what that would look like. This is the same chart as before, but now we're looking at the situation of somebody like Rosa who's unable to do their customary work due to risk starting early in pregnancy. So again, time off is job protections on the top, pay is on the bottom. So PDL, pregnancy disability leave, provides job protection for 4 months for Rosa. And then federal law, the Pregnant Workers Fairness Act, could provide additional job protection, however, without health insurance benefits for the duration of Rosa's pregnancy, as well as for childbirth recovery, absent undue hardship. So long as there's no substantial difficulty or expense on the employer. After that, still staying with job protection on the top, it is unlikely that Rosa would be eligible for baby bonding because she may not meet that 1,250 hour requirement in the way it sort of breaks down, because she hasn't even had the baby by the time the 4 months runs, but she could still have the 6 to 8 weeks postpartum for recovering from childbirth. What about pay? So looking at the bottom, during that period of time when Rosa is off, the 4 months plus the extra time that she's off during under the federal law, SDI is available. So SDI is available for the remaining 28 weeks of pregnancy due to the hazardous work, and then also for the 6 to 8 weeks of childbirth recovery. After that, even if the job's not protected, PFL would still be available to Rosa if that's, especially with seasonal work, sometimes job protection is actually not as important, then she could collect that benefit as well. Okay. Grace works at a call center. Her father, who has dementia, recently got lost after wandering outside when Grace's mother was in the shower. Grace's family decides that her parents will move in with her. This will allow Grace to support her 72-year-old mother, as caring for dad is an intense around-the-clock job. When her mother gets the flu, Grace uses up her state-mandated sick days. The following month, Grace is late on 2 occasions, in both instances because her father was experiencing a dementia-related health issue and she was needed to care for him. Dad has a medical appointment coming up when big health decisions are going to have to be made, and Grace asks to take off work early to attend those appointments. Her boss responds that Grace can't have any more time off and is going to have to decide whether she wants to take care of her parents or keep her job. So, assuming that Grace is eligible for CFRA, she's worked about 25 hours per week over the last year, then actually Grace does have a right to attend the appointments, to fill in for her mother when need arises, to take care of her dad, whether that's on sort of smaller chunks, like I need to go to the appointment, or maybe something bigger happens and she needs to take 2 weeks off. She has up to 12 weeks in the year where she can do that. And if Grace's boss ends up deterring her from taking the leave, she would still have had her rights violated, because, if he sort of says, you've got to choose, she chooses to stay at work. She's not like fired. She still would have had her rights violated because she had been discouraged from taking that leave. Okay, last slide, work-life laws, free services. We have our free legal helpline, and we provide services regardless of income level, regardless of immigration status. Questions about any of the stuff that we talked about today, whether it's health, caregiving, pregnancy, breastfeeding, please feel free to call us to ask about your legal rights or the rights of a loved one. We'll also take a little bit of time to answer questions from small employers who are trying to do the right thing and to follow the law, who don't have, the resources to get legal counsel. So please feel free to call us 415-703-8276 or hotline at worklifelaw.org. And then we have these guides. There's a QR code here on your screen, one on caregiving, one on pregnancy, childbirth, and lactation. All of this is available at Work-Life Law's website. And you are welcome, all of you on the council are welcome to contact me with any questions, send people to our helpline. Thank you. It's a real honor to be able to share all of this with you. And thank you so much for your service and your work, and congrats to the new council members.
Thank you.
Thank you.
That was really good.
We'll go to public comment.
Oh, I was
Right.
going to comment on what she had to say.
I know, but right now, first we have council members, then we have.
Oh.
Thank you, Liz, for that very clear, concise, and comprehensive presentation. Do we have any council member questions or comments?
Sure. This is Councilmember Glader. Thanks so much. That was really informative. And I guess I have one question for you as an expert. Are there areas that you regard as regulatory gaps? Because if our responsibility is to be thinking about where the need for regulation is greatest to clarify existing law, welcome your insight.
Yes, I'm so glad that you asked that question. So there are many gaps in the regulations where I wouldn't say it's a gap in terms of protections are not there, but the explanation in the regulations could be more clear to apply to all of the situations that we see coming up on our free legal helpline. And, I'm talking about stuff that's like in the weeds that we go back and forth with our callers every day about. And I could provide a list of those. Nobody wants to hear them right now, but, small things where it's like, well, that's unclear and it constantly is tripping up employers. Workers don't know what their rights are. And once you shouldn't have to really call our helpline to understand. That's not the goal. We want people to be able to understand and employers to be able to understand. So that's the first category. In terms of a gap, I think that what I mentioned earlier about the federal regulations on pregnancy being actually more protective than California is something that, as an advocate, I would love to see improved upon. And I think, yes, people have the federal regulations, but then they have to go to the EEOC instead of to CRD. It only applies to employers that have 15 or more employees instead of 5 or more employees. For the litigators amongst us, there are differences in what kinds of remedies and justice you're able to seek in court. Like there's a damages cap under the Pregnant Workers Fairness Act. And I think, I think that is one area where I would love to see changes, personally speaking. I'm sure there are others, and I'll kick myself for not thinking of them on the spot, but for sure that's something we see coming up all the time. And I also want to offer, one of the things that we can do at Work-Life Law is we, check in regularly about what our helpline callers, and we get like almost 600 callers a year, what our helpline callers are experiencing and where the gaps are for those people. And I think that, sort of writing up an analysis of that is definitely something that we could benefit from. Another area where we see gaps is accommodations for caregivers. So caregivers have access to leave, but often what they need is a slight schedule change, or to be able to work from home on some days. And that is one area where we are able to help people. People do have rights, but it's very unclear what their rights are. And it's like the number one thing that caregivers need, just very slight modifications that will allow them to meet their obligations to their employer, while also being able to take care of their family.
Thank you.
Can I ask a related question? This is Councilmember Chan. So in the areas where the federal regs are more protective than in California, are there efforts to revisit those at a federal level that you're aware of?
Well, so that's really interesting. Despite the leadership of the EEOC weaponizing our civil rights laws to, totally crush DEI efforts, to harm trans workers, to do all sorts of really terrible stuff that we would never stand for in California. The Pregnant Workers Fairness Act is actually something that the current chair of the EEOC and the administration support. And they are enforcing the law. There is one exception to that, which is in terms of, I'm telling you what the chair's political views are. I don't know what's actually going to happen. Nobody has a crystal ball, but the chair of the EEOC does not agree with the scope of related medical conditions. So does not believe that it should include things like fertility. And when I say does not believe, this is based on public things that she has said. This isn't just my opinion. She's put out documents objecting to these things, to the inclusion of fertility, abortion. There's also a court order ordering the EEOC to remove abortion from the protections in the regulations. That doesn't mean that the law doesn't provide those rights anymore. It just means that they are probably going to be stripped from the regulations. It seems fairly certain that there is going to be movement at the end of this year to take abortion out of the Pregnant Workers Fairness Act regulations. But all of the other things that I mentioned, the essential functions thing is in the statute, and the medical documentation. My understanding is that the chair is supportive of those things, as they are very important to pregnant workers, and she gets that, and cares about this issue. So of course, my job as an advocate is to worry about what could happen, but that is not what is keeping me up at night. I think those things are going to probably be protected. Yeah.
Director Kish.
This is Kevin Kish. Thank you for the presentation. I think everybody is alert to the fact that we just heard one of the clearest possible presentations on these laws. I'm willing to bet that nobody here, all of whom are lawyers, with some degree of expertise, would be able to potentially pass an exam on this, which raises two issues that I just want to say out loud. One, how on earth are people supposed to understand this stuff, who are trying to vindicate their rights or the rights of their loved ones? My personal view is that that is not accomplished through regulation. We have tried, and this is always an ongoing process, to put together some guidance for Californians to navigate some of these things. So if you go to our website, here's a plug for our website, you will find a new parents' rights guide, which allows you to answer basic questions. It's a little bit of an interactive guide that will give you some advice about whether you are in fact qualified. If you are Rosa in the hypothetical that was provided, you can type in the facts and answer the questions and be told, yes, this law applies to me. No, it doesn't. We also have a toolkit on job protected leave for employees with some interactive guides, some required postings, and some frequently asked questions. So we have provided some resources for individuals, for HR departments to try to navigate some of this stuff. It makes it a little bit difficult that there are multiple government agencies that are responsible for enforcing different aspects of this, including the wage replacement or element of all of this, which is so crucial for so many people. But there's that. Then, though, advocates also need guidance. Courts need guidance. Officials within the Civil Rights Department who are administering these laws on a daily basis need guidance, and their regulations really are quite useful and can be useful. And we have two things that I would just add to what Liz Morris has said in terms of gaps. One, there are no existing regulations on bereavement and reproductive loss leave. Those are new, relatively new protections that have come into California law. And the regulations that exist interpreting the California Family Rights Act and the Pregnancy Disability Act, right? Leave Act. Sorry. Also acronyms, right? Wow. Those regulations are decades old. And we are working in a subcommittee that we'll talk about later in this meeting on updates to those regulations. We'll hear about that. But it is one of the roles of this body to make sure that the regulations stay up to date, that they are not less protective than federal law when the statute supports that interpretation, and that we are making changes to reflect changes in our own state laws and also changes in the way people are understanding these laws through court decisions, et cetera. So that is an ongoing project that I view as quite urgent, actually. So thank you again for your presentation on this.
Yeah, and I think what you said of like these are decades old is exactly what I was trying to say, that there are these little nits, but it's like this doesn't make sense anymore. So I agree with that.
Councilmember Cho, I have a quick question. Could you say a little bit about who counts as a California employer in an era of remote work and with the gig economy?
So these laws apply to people who are working in California. It doesn't matter where the employer is. If the person is a worker in California and the employee, so the threshold, the 5 or more, could be just one employee in California and the rest are in Nevada, and that's okay.
Thank you.
Yeah.
Any other questions from council members? Okay, any comments from the public in person?
I do. Hi there, my name is Lacey Friedman, and I'm an advocate, a parent advocate, and I became a parent advocate when my child was in utero. So at 15 weeks old, I found out that there was something very serious going on. This was in 2001 when these protections were not in place, and I feel like I could almost cry talking about it. So at the time, there's something to think about. At the time, clearly, I couldn't even go off after my child was gone. It was born. The doctors had to claim that there was something wrong with me. We couldn't just say my child has a lot of disabilities. I'm living in the Ronald McDonald House and I can't come to work. At the time, we had to get a doctor to say I was ill because I didn't have any of those protections. I would have lost my job. We didn't have FMLA. We didn't have 12 weeks of paid leave. So thank gosh for all of this. I mean, it made a big difference. I mean, not for me, but also I would say, first of all, did you say that in California, if you can't do the specific type of job at all, your essential job, that you might not be protected?
So in California, if you cannot do an essential function of your job, then you could, if there is one available and it's not, your employer could maybe move you into a different job, or if it's just a part of your job, change your job functions. Maybe somebody else could do that piece of your job. Maybe nobody actually needs to do it for the next 3 months, whatever the solution is. If that's not feasible because, the crops all have pesticides on them and there's nothing else to do at that work site, then leave could be an option.
Okay, well, I don't know in depth enough, but there are jobs. So I'm an inspector, I'm an environmental regulator, and everything I do is around toxics. And so I don't, there would be no other real job for me. So I don't know if that's something that people have taken a look at to say, you said there might be available. So that, would be a problem.
The reason I use the word might is because I'm a lawyer and we always do that. There would be leave available if you have an employer that has 5 or more employees, which it sounds like you do, and it could be paid if you've paid into the SDI fund. I don't know if you're a public sector worker, maybe you have, that's why I say might, but as a basic matter, leave would be available.
All right, so the other comment you would, Mr. Kirsch, you were talking about how to get the information out. I would say one thing that people haven't talked about is perhaps genetic counselors, because they give you a lot of your initial information, and to know what you have to do with your job when you know that I'm going to, be living in a hospital for the next 5 months. What am I going to do? There's a lot to think about, and they could provide information. They're not just giving you health information, but they're telling you what things are going to come next. So
that's really smart, working with healthcare providers.
Thank you for your comment. Any remote public comments?
Yes. RAJ, you can go ahead.
Hi, how you guys doing? Good evening. My name is Rainisha Hubbard. I am a mother, a caregiver, an advocate, a founder of Coalition of Parents Nationwide. I have worked as an in-home care provider and previously worked, I was an armed security guard. I worked in hospitality industries. I am currently completing my Medicare Peer Support Specialist certification training to help individuals and families facing mental health, disability, housing, and child welfare challenges. My advocacy comes from lived experience. I have spent 10, 11 years navigating the dependency court proceedings, special education services, disability-related needs, housing accommodations, requests for public benefits, and mental health systems and victim of crime systems. While raising and caring for my children, these experiences have showed me how difficult it can be for families to access services, obtain accommodations, secure safe housing, and receive disability benefits, even when substantial evidence and documents are provided. I speak today not only for my family, but for many families across California facing the same similar barriers. I believe the government system should be accessible, transparent, accountable, and responsive to the people that they serve, especially children and parents, caregivers, seniors, and people with disabilities. My son, he spent 9 years in foster care. When he left, he didn't have any mental health issues, disabilities. When he came back, he had all the mental health issues and disabilities that I have to fix now. I'm left to fix it all by myself. I applied for in-home care IHSS for him. I had to stop working my full-time IHSS job to be his full-time IHSS provider. And I applied. County said, yeah, he qualifies, but we're going to still deny him. And then I had to go to the appeals, and they still didn't have a reason to deny a disabled child. So many people are dealing with disability. We are not able to get our SSI. I've worked all my life. I have like over 40 some credits. I've worked, I paid into the system. I'm a law-abiding citizen. state disability, the housing accommodations. People are just being left homeless. But thank you so much. I just wanted to, you know, put my public comment down, just to let you guys know that the
Next we have Devin Woodfine.
are,
Go ahead, Devin.
Hello, my name is Devin Woodfine. I'm also an IHS provider. I recently became one last September of last year for my mom. She has various physical disabilities, and I've always been her caregiver for the last couple of years, and having to navigate getting more hours for her because the issues that she have require a lot more care has been very difficult. I feel like there's a either, dealing with the workers who are approving hours and coming and doing evaluation. I understand they have a lot of cases, so it can be burdensome sometimes dealing with them, but I feel like there's a lack of humanity. And when a worker like me is trying to provide care and I can see that my mom needs more assistance. And I've also even dealt with the issues with discrimination, retaliation, harassment. I helped my mom file a CCRD complaint in the housing space against our landlord. And originally it started off at HUD. HUD took up the case and sent it to CCRD. When it was being investigated by Rashawn Nicholas, she refused to follow what HUD determined was the disability refusal accommodations and discrimination piece. And I had to open up a second case. In my second case, the investigator and his supervisor agreed that we did actually experience this, but there was no need to open up the second case. So both my cases ended up getting closed out. The respondent, the housing provider, was able to lie and not provide any accurate information, yet I had to get my state representative Sade El Harwari and Senator Lola Smallwood to step in, and even when they reached out, we have not gotten a proper response. I would love to be able to speak and get this addressed because my mom is over 60, she's disabled, and she fell in court because this owner has been retaliating against her. And it's very harmful when you have this and you're trying to do your best to provide support and give them assistance. Thank you.
Thank you for your comment.
Next we have Elle Rose.
Thank you very much. I too, I'm a professor, unrelated area, but I have to, first of all, commend the presentation. Excellent. Really good, a good job at being clear, instructing people, just really, really good. I look back and I lost a job in caring for my father, who was deceased for some years now. Now, that was an employer with less than 5 employees. So I wouldn't have been covered anyway. But I am talking today because I want to highlight the comment about education here. A lot of folks don't even know about the Civil Rights Department, don't even know to go online and to even learn about filing a complaint. And I want to just suggest that perhaps the council consider utilizing, kind of taking the idea from the Bar Association, which installed somebody weekly at the federal courts in the Northern District who helps, folks who are not attorneys, don't know about this stuff, want to file a complaint. Consider that option in expanding your ideas of how do you educate Californians about their rights. Once again, just thank you all for what you do. And we are very lucky to be in the state of California. Thank you.
Thank you for your comment.
Next we have 1-831-613. Go ahead. You will have to unmute on your phone. We can't hear you.
Hello.
We can hear you.
Hello. Hi. Can you guys hear me?
Yes, we can hear you.
Okay. Yeah. I just okay. I have a case for 2024, and then so the state told me they go give me a protection, and then okay, I don't still receive my post office through 2024, so all my rights, all my private rights, so they're still violent. So I sent a lot of reports. I make a lot of claimants, but I see nobody can hear me. I don't know. So and then I have a cool case, so I need the protection, but nothing. So that's my reason for that's what I still here.
Thank you for your comment.
So
Okay, wait. Before you finish, what are your last? Okay. Next is PH Dr. Muhara. Go ahead. You can begin. We are unable to hear you if you're speaking. Okay, we'll come back to you. All right. Mr. Kaya Owen. Go ahead.
Good morning. Good afternoon. My name is Kai On from Sacramento. I filed a complaint about Department of Motor Vehicle discriminate my health condition to deny my request to reinstate as an accounting technician. State Personnel Board refused my request to have a medical officer evaluation from them. However, CRD staff use a non-related reason to close my complaint. Case number 202511-32239-516. CRD management. Please look into any misconduct activity inside CRD. My second topic is about political power is controlling State Bar of California, Chief Justice, and Attorney General not to investigate Sacramento DA office and SPD make up a story that fake killer Mr. Jung So Fong hit and run killed my father Woon Kong on. DA case number 99F08735. I talked about this topic in July 2024 Civil Rights Council meeting at UC Berkeley. Sacramento City Council even used a UC Davis internship student email me a fake report. But UC Davis Law School Dean ignored my complaint letter. This year, I went to governor's office in San Francisco and Sacramento, but governor's office doesn't take any action. Even Senate and Assembly office ignore my complaint. I went to Judicial Council 5 times. Please watch my public comment at Judicial Council meeting on December 12, 2025, 25th, at the beginning of the public comment. It needs Civil Rights Department to handle this kind of complaint. On October 23rd, 1999, I was searching for my missing father. I drove to a scene and a female law enforcement officer showed me my father's wallet. She told me my father's body was removed from the scene and it was a hit and run. 26 years ago, political power already controlled Sacramento law enforcement to make up a fake story of hit and one and a fake killer. The government that you are serving is controlled by the political power. The political power can override any Civil Rights Council's policy. Please take a look into my issue. Thank you all your time. I just email the information to the Civil Rights Council. Thank you.
Thank you for your comment.
Just a reminder for participants, you may make one comment per item. If you have another comment on different items, we'll call on you again. I'm going to go back to PhDR Muharrem to see if you're able to give your comment now. You'll have to unmute to give your comment. Okay. We'll move on to, okay, that's it.
I will say that, I will say that, Renisha Hubbard, who spoke earlier, and Kai An both also sent emails with their comments, which will be shared in full with the council.
Okay, thank you, Rachel. Thank you for that public comment, period. We are now moving on to agenda item 8, is that right? Okay, and thank you again, Liz, for coming by and giving that very helpful presentation. Agenda item 8 is council member reports and council acknowledgements. This is an opportunity for council members to provide information to each other and to the public. For example, upcoming events of interest that are relevant to the council's work. Do we have any reports from the council members? Hearing none. Do we have any comments from the public in person?
My name is Lacey Friedman. Well, I thought I had read that there was something on the agenda recently at a subcommittee. I was talking about the people first language versus identity first language. Didn't you have an ongoing subcommittee?
So this is no. No. So this is an odd formulation because as a public body, typically you just make the comment and we don't respond.
Oh.
But we're in kind of an intimate setting and we're all sitting at the same table. So it feels really weird not to respond to a direct question. But no, to my recollection, we have not had a subcommittee or an agenda item on that matter. So it was perhaps a different public body.
Thank you for your comment. Any remote public comment?
Let's see.
Just a reminder that public comment should be related to this agenda item. And if it's not related to this agenda item, we ask that you save it to the end when we take unrelated public comments.
Okay, great. So RAJ, you can unmute.
Okay, hi. For the reports and council's acknowledgement, well, I hope y'all report states in there that you know, some of the disability folks are being left behind. We are unable to navigate, you know, these systems. It's very hard for us. It's very hard for us, you know, and we're navigating the appeals and things like that. So I just would like for everybody to be aware that it's really, really hard for people with disability to go and apply for these programs. And then we're being lied to. The people that is working or doing an application don't have no idea, or our paperwork are being thrown in the trash, especially for Social Security. They are not checking the online portals. They're saying that they didn't get the documents, which, you know, we drop off the documents and things like that so that they can have these documents. But it's really frustrating for the disabled folks around the world. We having a hard time accessing the benefits that we are entitled to and that we qualify for. So that's all I just wanted to say. Thank you guys so much.
Thank you for your comment. Any other public comments remotely?
No comments.
Okay, thank you. Moving on to item number 9. The next order of business is the Civil Rights Department report. I will turn to Deputy Director Julia Parrish for the report.
Thank you. Speaking as Julia Parrish, Deputy Director of Legislation, Regulation, and Policy at the Civil Rights Department. I just wanted to take the opportunity to report on an exciting recent event that the Civil Rights Department was able to be a part of, which was our Civil Rights Summit. It happened on May 11th. There's, video and photos and other news items available about it. But from a personal note, it was really exciting to take part in it. As far as I'm aware, it was our first annual event. It brought together California versus Hate, the Commission on the State of Hate, and a wide variety of groups from sort of local grassroots organizers to elected officials, academics, and artists. And it was a really varied program that included performances and lofty intellectual discussions and sort of everything in between, and a really nice opportunity for folks to come together in a shared space to talk about our shared vision and dream of, a hate-free California. And this was sort of on the heels of new data that showed that 3.1 million Californians had experienced an act of hate in the past year. And that's, some sobering statistics. And I think that the ingenuity of the event really brought together different ways that everyone, from individuals to sort of collective actions, can help stop that, right? So there was a discussion about media and sports, all the way to sort of policy regulating and youth in action. So I encourage anyone to check out those links on our website, and hopefully we can all come together to stop hate. And one of the related bodies that did a presentation about the data collection is the Commission on the State of Hate, which is also a body similar to the Civil Rights Council that has a statutory mandate to report on hate and make policy recommendations to them. So, let's see. And I wanted to pass it to Rachel, who's going to give an update about some recently passed legislation.
Thank you, Rachel Langston. I wanted to share with the council and the public several substantive changes to the law that are relevant to, or may become relevant to the work of the council. Several of these, as you'll see, were already covered by Liz in her fantastic presentation, so I won't spend too much time on those. The one that was not yet covered was AB 2499, a bill that passed in 2024 and was amended, I think, last year. And basically what this law did is it transferred some language that was in the labor code over to the Fair Employment and Housing Act. And that language provides protections, leave in particular for jury service and court appearances, job protected leave. And it also provides leave for victims of violence and their families for various reasons, including safety safety planning, relocating, speaking to domestic violence counselors, etc. In addition, this law protects victims of violence from discrimination at the workplace, and also provides for reasonable safety-related accommodations for victims of violence and family members of victims. And so that is a really important right that now CRD oversees. Briefly, as Liz mentioned, SB 848, which was passed in 2023, provides up to 5 days of leave for reproductive loss following a miscarriage, stillbirth, failed surrogacy, failed adoption, or failed assisted reproduction. AB 1041 passed in 2022, added designated person the list of individuals for whom an employee can take sick or leave. So it sort of expands on the idea of family to sort of meet the modern types of families that we have today. And then finally, 1949 passed in 2022 bereavement leave, which requires employers to grant up to 5 days of job protected leave following the death of a child, spouse, domestic partner, parent, grandparent, grandchild, or sibling. And that must be taken within 3 months of the death. So I won't spend too much other time on this, but just wanted to kind of share some of the laws that come up. New laws are something that often need regulations. And so just wanted to make everyone aware of sort of what was relatively new out there.
Councilmember Cho, thank you, Rachel. Do we have any council member comments or questions?
Councilmember Tala, thanks, Julia, for that report. I'm just curious whether there are any plans to make the summit annual or periodic. And then I have one question also for you, Rachel, which is, of the recently enacted legislation, is there anything that needs regulatory work that isn't already assigned to a subcommittee?
There are no current plans for the next iteration. And we're going to talk about the subcommittees in a second.
Okay, great.
Yeah.
Any other comments or questions from council members? Any comments from the public in person? Any remote public comments?
Yes, RAJ. Please go ahead.
Oh, I just want to say thank you guys for doing what you're doing. I appreciate it. And and another thing, it just happened to me. I went up there to the county building as well. I was screamed at by a worker. And of course I have disabilities. He just told me, I'm not going to log you in. You need to get back in line and wait for somebody else to help you. So they're dealing with people with disabilities, and as a county worker at the front, eligibility worker should not be talking to people like that, especially with disabilities. I filed a civil rights complaint. Of course, they didn't do anything, but I just stood there and got screamed at in front of everybody. There was a lot of witnesses, even the security guards. It was very frightening. It was very scary. I am a domestic violence survivor, so that was really terrifying for me to be getting screamed at by an eligibility worker named Dumas, just for coming in, just to try to check in and get help. Should no person be treated like that ever? Just trying to get some services. But thank you guys so much.
Thank you for your comment. Are there any other remote public comments?
No.
No, okay. Next is agenda item number 10. This is Councilmember Cho.
Sorry, oh no. Pen went up, pen went down.
Councilmember Cho, the next matter on the agenda is a presentation by Civil Rights Department staff regarding council's subcommittee responsibilities and time commitments. And I will turn it over to Senior Counsel Suj Lee.
Next on the agenda, we're going to be you guys are going to be discussing the council subcommittee structure and council member assignments. And so CRD staff thought it would be a great opportunity to do an overview of typical responsibilities, expectations, and time commitments associated with serving on the committee, especially given the number of new council members who would have joined us this year. So we just want to go over how subcommittees operate, the types of projects they may undertake, and the level of engagements that's generally required. So subcommittees, they generally consist of 2 council members and are supported by 1 or more CRD staff members. Typically, the subcommittees will meet on a monthly basis, but they may meet more or less frequently depending on the scope and urgency of the work. And meetings can be as short as 30 minutes, but up to 2 hours. The workloads associated with different subcommittees can vary considerably. While some require just periodic meetings, others may involve more frequent meetings or more significant work between meetings. And historically, council members have served on 2 to 3 subcommittees at a time. And the specific responsibilities of the subcommittee will vary depending on their purpose. So obviously one of the main responsibilities of the council is to propound regulations. And so regulatory subcommittees are established to assist the council and staff in the development, review, and adoption of proposed regulatory. Regulatory subcommittee tasks include, but are not limited to, identifying and researching policy issues, considering the scope and content of proposed regulations, reviewing and drafting proposed regulatory text, reviewing and drafting supporting rulemaking documents, and these include the initial statement of reasons, which is often referred to as the ISOR. That's a document that's submitted upon the initiation of the rulemaking process with the Office of Administrative Law, which we also refer to as OAL. The ISOR explains the purpose of the proposed regulations, the problems they're intended to address, the legal authority for adopting those regulations, and the rationale for the specific proposed regulatory language. The final statement of reasons, also referred to as SAPSOR, is a document that is prepared after all public comment on the rulemaking has concluded and is submitted with the final proposed regulations for OAL approval. The FSOR explains any changes that have been made to the proposed regulations since the rulemaking process was initiated, responds to all public comments that have been received regarding the proposed regulations, and provides the final justification for the regulations as adopted. Other regulatory subcommittee tasks also include presenting at and participating in public hearings, reviewing public comments and assisting staff in the development of responses to such comments, and working with staff and coordinating with OAL to initiate the formal rulemaking process, to submit the final draft regulations for approval, and assisting staff in addressing issues that have been raised by OAL during their review process. In addition to regulatory subcommittees, the council can establish subcommittees to undertake a variety of other activities, which may include, but are not limited to, engaging with stakeholders, planning and hosting informational or other public hearings, conducting research on emerging or priority issues, preparing and publishing white papers or reports, developing outreach and education materials, or advising staff on outreach and educational efforts. And so council members may wish to consider their level of interest and ability to commit sufficient time and energy to both attending meetings and carrying out the substantive work of the subcommittees when considering the council's overall subcommittee structure, as well as individual council members' assignments, including when proposing any new subcommittees, suggesting the disbanding of existing committees, and volunteering for or accepting subcommittee assignments.
Councilmember Cho, thank you, Suj. Do we have any council member comments or questions? Any reflections from our more seasoned council members on serving on a subcommittee? Also welcome.
This is Councilmember Chan. I'll just say that for folks who aren't as steeped in civil rights laws, the staff are a really, really great resource.
I would second that, Councilmember Later. Sorry.
Thank you. Do we have, Councilmember Cho, do we have any comments from the public in person? No comments? Do we have any remote public comments?
RAJ, go ahead.
Oh yeah, sorry about that. I left out. I went to school for administrative criminal law and justice too as well. So I just wanted to throw that out there too, under my resume.
Thank you for your, any other remote public comments? No other remote public comments. We are now going to move on to,
Can I just interject?
Sure.
quickly, we've been sitting here for a long time, so I don't know if you want to see if folks are interested in maybe a 5 or 10 minute break.
I think that's an excellent idea. What is the correct way to do this procedurally?
We can just take a.
Okay, we are going to take, should we do 5 or 10 preferences? Let's be back at 1:30, 6-minute break.
Okay, so we will resume the meeting at 1:30.
Okay, thank you.
So I'm gonna grab that.
Right, we are reconvening council at 1:30 and we have a forum. Moving on to agenda item 11, subcommittee updates, assignments, and creations. I believe the staff is going to give us an overview of current subcommittees and assignments. And I apologize, this is Councilmember Cho. Is it Rachel? Okay.
This is Rachel Langston. I am proposing, well, this agenda item is to go over existing subcommittees, talk about their purpose, what their status is currently, what the membership is, and if any vacancies need to be filled. And then we will also, after that, the council will have a discussion about possible new subcommittees that will be added. After we've come up with a list, there will be a kind of lead a discussion to make some decisions about the open questions around forming new subcommittees, volunteers to join existing and new subcommittees, etc. We'll then have public comments and come back together. Ideally, we'll have reached these decisions. I can recap everything we decided. We'll have, if it works for the council, one omnibus motion basically to approve all of the new decisions that the council made today regarding subcommittees. So with that, I will go ahead and go over existing subcommittees. The first is the 11135 Guidance Subcommittee. Currently that's staffed by Councilmember Glader and has one vacancy. The purpose was to work with Berkeley students to create guidance relating to the 11135 regulations that were recently propounded by the council. Those materials are under review by CRD's outreach and education team. And the subcommittee has talked a bit about moving on to some regulatory cleanup of the recently propounded regulations. So we'll talk more about that today. Moving on, the Protected Employment Leaves and Reasonable Accommodation Subcommittee. This is staffed by Council Members Chan and Cameron Banks. Its purpose is to promulgate regulations relating to pregnancy leave and accommodations, CFRA bonding leave, and new implementing regulations for bereavement leave and reproductive loss leave. The text is currently at various stages of review. And then I think the next step will be to reconvene and continue to finalize the text and move forward. There was a discussion about possibly separating the two packages, not necessarily separating into two subcommittees, but for the ability to sort of handle things a little bit more in a more tailored way, separate into two packages that can be staggered, one for pregnancy and CFRA bonding, and the other for reproductive loss leave and bereavement leave. So we'll talk more about that when we go back to make some decisions. The Public Civil Rights Hearings Subcommittee is staffed by Councilmember Chan. There is one vacancy. Its purpose is to organize and host informational hearings on civil rights issues related to the work of the council. We will go back and ask if there's a volunteer to join Councilmember Chan on this subcommittee. There is a Paid Data Regulations Subcommittee staffed by Council Members Cameron Banks and Chan. Its purpose is to promulgate regulations implementing the Paid Data Reporting Statute. And its status, the initial text is under review by the administration. So at this point, the council, the subcommittee is awaiting that feedback and will begin formal rulemaking once that is received. Next, we have the Contractor Non-Discrimination and Compliance Subcommittee. Currently, this is unstaffed. The purpose was to promulgate regulations relating to prohibitions for state contractors against violating PIHA and Government Code 11135. These regulations were finalized and approved and went into effect on April 1st of this year. So what we will go back to is propose disbanding the committee. So those are the existing committees, and I'll recap them as we kind of go back through and make some decisions. I did want to open it up now to ideas for additional subcommittees. I will note that the department does have some ideas for potential new subcommittees and would be happy to share those ideas if the council would want to hear them.
Thank you, Rachel. This is Councilmember Cho. I'm very interested in hearing those ideas, and I can see a lot of agreements at the table.
All right. So first is on leave to attend court and leave and accommodations for victims of violence and their families, and family members of victims of violence. The purpose of this is to promulgate implementing regulations for the new regulations under Government Code Section 12945.8. This is a new protection that Liz spoke about and then I briefly spoke about, which entitles employees to leave to attend court for various reasons. It also provides leave and other protections for victims of violence and family members of victims, including leave from work to relocate or create a safety plan, and counseling, or take care of other similar responsibilities. It also prohibits discrimination on the basis of a known status as a victim of violence and or a family member of a victim. And finally, it provides for reasonable accommodations that are safety related for victims of violence or family members of victims. So that is one idea. The department has started thinking through what these regulations would look like, doing some preliminary drafting in case this is something that the council would be open to taking on. The next idea that the department had was automated decision-making systems and housing subcommittee. So as you know, last year, I believe time kind of has no meaning sometimes, but last year, the council finished and automated decision-making systems and employment regulations. And so there was some thoughts that this might be the potential next step in the effort to regulate AI and automated decision-making systems. Finally, there is a subcommittee to consider federal policy changes. This was previously a subcommittee, but was disbanded due to a shortage of council members. And so it's something that we're open to bringing back. And so those are the department's 3 thoughts or ideas. But I do want to open the floor for any additional ideas that any council members may have for additional committees.
Councilmember Cho, thank you, Rachel. Does any council member want to add more ideas to the table or have any questions about the ideas that have been shared?
This is Yvette. I just had a question. I just want to clarify that you said those were the 3, but I had victims of violence, automated decision-making systems in employment, housing, and then federal policy changes. Did I?
Well, the automated decision system would be related to housing.
Got it.
Because the department previously issued regulations regarding.
Thank you.
Yeah, employment.
Councilmember Cho, I have a couple of questions. One was for the Public Civil Rights Hearing Subcommittee. I'm wondering if maybe Councilmember Chan or others who are here can say a little more about what that was intended to accomplish.
I'm happy to volunteer and Councilmember Chan, feel free to jump in. The purpose of that subcommittee, well, taking a step back, the council is not only charged with issuing substantive regulations that promulgate the statutes that CRD that are within CRD's enforcement jurisdiction, but they also are charged with holding informational hearings on issues that are related to the work of the council or possible future work that the council is interested in learning more about. We've had, for instance, in the past, a informational hearing on AI in different contexts, and I believe also on the Fair Chance Act and some issues and that need to be some gaps that needed to perhaps be filled. So it's items like that often where it may be something that the council is considering regulating or just wants more information about. They're open to the public. They usually include experts on these various issues. And so that is the intent of the committee. That's one of the few non-regulatory subcommittees.
Can I add something?
Yes, please.
This is Director Kish. I'm just going to add, holding a public hearing on an issue affecting Californian civil rights requires a great deal of coordination and talking. That is, we have found historically is helpful to work with the subcommittee to identify topics, do a little bit of background research, to bring ideas to the full council, to then work on issuing invitations to work with invited speakers on their comments. So that's the idea behind this committee, which if reformed would likely have as its first task identifying topics to space out for the next year and a half, something like that.
I'll just add, this is Councilmember Chan. I think it was maybe last year or the year before that we did one that was joint with the Commission on the State of Hate, focused on disability. So extra coordination there, but that was one of the more recent ones.
That's very helpful. Thank you. This is Councilmember Cho. And then I think, Rachel, your comment anticipated my next question, which was about the ADS and Housing Subcommittee. I remember seeing that the ADS and employment rulemaking started as a public hearing, I think back in 2021 or so, and then evolved or ripened into rulemaking. And I'm curious if that's something that, if that subcommittee were to go that route, then that would be both like a public hearing / regulatory subcommittee.
It could be however you want to do it. But yes, I mean, that could be something that ADS and Housing Subcommittee put together as sort of a first step in exploring potential regulations. But that would be the subcommittee's decision, and staff would be, of course, willing to help where needed as far as sharing our perspective or assisting council members on the committee.
And this is Director Kish. In my experience, it's been helpful, I think, often to form a subcommittee with a relatively limited mandate. And so the subcommittee might form to hold a hearing to get input about this and then choose to form a subcommittee. And maybe the same subcommittee members want to be on a regulatory subcommittee if one emerges from that public hearing, or maybe not. And then I just wanted to add, I pulled up the statutory language just as a reminder to the body that the authority for holding hearings is much broader than the rulemaking authority, which is of course limited to a certain number of laws and is in fact, excuse me, time marches inexorably on with my eyesight. Hold hearings and issue publications, results of inquiries and research and reports to the governor and the legislature that in its judgment, meaning the judgment of the council, will tend to aid in effectuating the purpose of the Fair Employment and Housing Act, promote goodwill, cooperation, and conciliation, and minimize or eliminate unlawful discrimination or advance civil rights in the state of California. So it's a broad mandate for the public hearings.
Thank you. Does anyone have any questions about the subcommittee?
I have a follow-up question about the public civil rights hearings. Are they, so I understand it makes perfect sense that a subcommittee sort of focus on a topic, but then once a hearing is determined to be held, is the whole council attending and holding the hearing? Okay, got it. Okay,
Yes,
so it's
the
not
committee
just
does the planning and the expert invitation.
And one other way of doing this is to form a planning subcommittee to come up with ideas for public hearings, present that to the full council, have the council vote on topics, and then a different subcommittee can form to actually move the hearing forward. If it's within the special interest or expertise of a person.
Okay. Hugely. So there, like I think in the slide we went over, there is an existing current subcommittee to do public hearings. I think the federal policy changes wasn't intended to focus on that one topic, but we still have an open subcommittee that could be the vehicle, right, to do that kind of public.
I see. Okay, Councilmember Cho. So the Public Civil Rights Hearing Subcommittee is a subcommittee to explore potential topics for a public civil rights hearing. And then the subcommittee to consider federal policy changes is actually, I would love to turn that back over to Sam. Can you say more about what that subcommittee does?
Sure, this is Rachel. So essentially the purpose of the subcommittee to consider federal policy changes is to sort of look at the current state of federal civil rights laws and regulations, guidance around those various laws that are basically counterparts to many of the laws we have in California. And to the extent that there are gaps found in either available guidance or regulatory regulations, to sort of think through whether it would make sense to act in some way to fill those gaps or to do something else, have a hearing and think through what that would look like. So it's basically just looking at the current status of federal civil rights law and seeing where there are gaps and what the council might want to do, if anything, around those particular issues.
Councilmember Cho, I see. That seems like that scope is quite large, and I'm curious whether it makes sense to either divide it or start it somewhere, like for example, in employment or in housing.
Sure, I think that definitely is up to the council, and it could be focused on one particular topic or arena at a time. The name of the subcommittee would just allow for choice regarding what issue or issues you wanted to cover. But I don't see that would be undoable to tailor and focus on one issue at a time.
Councilmember Cho. Oh, sorry, go ahead.
So sorry, Julia Parrish. So also, it doesn't have to be a perfect exhaustive list at this moment in time, because we can vote to disband and form other subcommittees as time goes on. So we don't need to create the whole universe of subcommittees in this one meeting.
Councilmember Cho, I'll ask maybe one more clarification question. I don't like to hog the mic so much, typically. For the subcommittee on leave and accommodations, I think someone, perhaps Rachel, mentioned that there's the idea is on the table to split the pregnancy and CIPRA regs into its own package and the repro loss leave, bereavement leave into a second package. So for the council members on that subcommittee, is this something where you're staffing I think what I'm trying to figure out is there a vacancy because of a potential split, or do we not have to think about staffing this because there either won't be a split or the same council members will be staffing both subcommittees?
It will be one subcommittee, staffed by the current members, council members Chan and Cameron Banks. The reason for that is because this subcommittee is active and has talked sort of about the full menu of these regulations that we're thinking about. And so it might be tricky to now separate it into another committee as far as complying with Bagley-Keene and things such as that. So the idea would be that the same council members would work on one package and then another. Again, they would be somewhat staggered, so it wouldn't be like everything all at once. And the staff, ideally, this committee would be staffed by 2 staff members, one for each package. So that would be kind of it's the same content, just sort of separated for clarity and putting it in chunks so that we don't have a huge regulatory package, which can be difficult to move. So that's the thinking.
Councilmember Cho got it. Thank you, Rachel. Okay, so for the purposes of the new council members, you need to either volunteer for a subcommittee or be voluntold for a subcommittee. It sounds like the options are 11135 guidance with Councilmember Glader, the Public Civil Rights Hearing Subcommittee with Councilmember Chan, the leave to attend court, regulatory subcommittee idea, the ADS and housing subcommittee idea, and then the subcommittee to consider federal policy changes idea. Is that right?
Yes, and I can go over them now so that we can talk about whether we want to form any of these new subcommittees, and B, if so, who would like to staff them, as well as who would like to fill vacancies in current. And then I can ask for public comment. I can recap all of this at the end and we can vote on it all at once. But let's just discuss and figure out at this point is my big. So I'll go through questions that are for the council's consideration. Regarding the current committees, 11135. Yes, the initial question is whether there's a willingness to change the focus to promulgating additional sort of cleanup regulations, or if there's any concern regarding that.
So Councilmember Lader, I'm curious your thoughts, Rachel, on whether there's cleanup that's necessary at this point, and if so, then that makes sense.
Yeah, I mean, based on the process of promulgating the first set of regulations, I think there are areas that could be helpful to explore for additional regulations. But again, the ultimate decision is yours or the council's. But that is just my personal opinion that bears no weight. So
aside from your expertise, Rachel.
So are you're open to
Yes, if the information gathered on the implementation so far is such that there are areas that require clarification that we should address, then yes.
Okay, and then do we have any volunteers to we have one vacancy. Any volunteers to join Councilmember Glader on the 11135 subcommittee?
This is Director Kish. I'd like to make a brief pitch. 1113 Government Code 11135 is the state equivalent to federal Title VI, which prohibits all forms of discrimination in government funded activities and programs. This is a law that was passed, I believe, in 1976, that had initial implementing regulations dating to the early 1980s that had not been touched in more than 40 years when the council took them on. The council then spent 6 or 7 years covering different terms of council members to draft and then finally move a set of regulations updating this kind of core civil rights law for the current era that we find ourselves in. Based on, there's a little overlap here with the potential subcommittee on federal changes, but you know, Title VI is an interesting place to start thinking about where state law might have some regulations. The subcommittee eventually for 11135 recognized that it could not touch every possible area of regulatory guidance that would be helpful to folks in this really big area. So it's an important topic. I do think that they did they meaning the prior council did a very heavy lift in updating regulations that had not been touched in 40 years, and now would be a little bit of a lighter touch to identify certain areas, certain definitions that could use clarification. So a very important job, not a 7-year job.
Can I ask the council member later? Can I ask a question about that, Kevin? Because that's important. What is the time frame that might be relevant for each of the subcommittees? Now that I think about it, but
I have learned not not to laugh in the at date. Look, I think that this is a lengthy process. I think that this is why council members can step off of this body having worked on essentially a single substantive piece of rulemaking with pride. So it also depends on the amount of time that you have as a volunteer to devote to the project. But with so for example, this project, which is, let's take a look at what we just did, which just got approved last year, and see like, this actually maybe was a compromise to get it through that was not helpful in the end of the day. That I think, you can do that initial work in a couple of meetings, especially if you're starting from a place where we have collected some feedback about implementation. Then it's just a question of your time and staff time in putting together a proposed regulatory package and review time. But ideally, we are not talking longer than 2 years. And I say 2 years because the formal rulemaking process cannot be longer than 1 year, right? So from the moment it is introduced in informal rulemaking, it has to be completed within 1 year. Sometimes we think, oh yeah, we're only going to do like 1 round, but then there's public comment and the body decides to change it, and then you go months and months and months. But I certainly think that this subcommittee could put together the package in a shorter time frame than 1 year. I'm looking at people who actually have to do this instead of myself. And then, so I think you could get to a point where you're introducing a public document, potentially this calendar year. I don't know.
Next year.
Maybe next year. Depending on what else is going on.
Thank you.
Yeah.
Any other comments on the 11135 subcommittee from the council, and then we'll move to the public after we get through all of them.
I want to just note that subcommittees do not have to have 2 people. That's often recommended to handle workload, but they could have 1 or 2 people. Yeah.
Yes. So that said, would anyone like to join Councilmember Leader on the 135 regulatory subcommittee? Don't be shy.
This is Yvette. I can do that.
Thank you, Councilmember Pena. Okay. moving on to the Protected Employment Leave and Revitalization Subcommittee. This one, like I said, is fully staffed. And so we can go forward. The next one. The Public Civil Rights Hearing Subcommittee is currently staffed only by Councilmember Chan. Would anyone like to volunteer to fill that, the other potential position?
This is Director Kish. I have a question.
Yes.
And I have not talked to you about it, but do you want to still be on the subcommittee? Considering that you are already on 2 other subcommittees, and I don't think that there would be a Bagley-Keene issue with moving you off of the public hearing subcommittee if that was what you wanted to do, in which case it could be staffed by new council members. This is not me nudging you to do that, but offering you that option.
No, I'd like to stay on.
Okay.
Anyone like to join?
This is Councilmember Acevedo. Yeah, I think Californians are hungry to see what the state can do in this era of federal change in civil rights, enforcement, regulation, and all that kind of stuff. So I think hearing from the public is something that's really critical at this time.
Thank you. So I did want to, and we can change how this works, but this is the Public Civil Rights Hearing Subcommittee. There's also a proposal for a subcommittee to consider federal policy changes. If we want to combine those in some way, we can certainly do that. I don't know if folks have thoughts on that, because it does seem like we've talked about them as sort of complementary. So I just wanted to throw that out there. I don't know, Kevin, if you have thoughts.
That would not be my personal recommendation, just because I think that the federal changes is going to be looking at actual retraction of guidance, change in federal regs, to make proposals for whether California should respond, whereas the public hearing subcommittee is really much broader.
Okay, so just to confirm, so Councilmember Acevedo, you would like to be on the Public Civil Rights Hearing Subcommittee with Councilmember Chan?
I would.
Okay, great. The last matter regarding current subcommittees is that the work of the Contractor Non-Discrimination and Compliance Subcommittee has concluded. And so there will be a proposal to disband that subcommittee. If anybody has any questions or concerns, we can certainly discuss those now. Okay, hearing none. Moving on to the ideas for future subcommittees. Again, it is not too late to suggest other ideas that any of the council members have for additional committees. So feel free to jump in. The ones that we have talked about, first, regulations regarding leave and other protections for employees to attend court, and leave and safety related accommodations for victims of violence and family members of victims. This will be, I will work to shorten this title if we do move forward, but how do council members feel about forming this subcommittee, or are there any questions about it?
This is Councilmember Tala. It seems as though it's an important subcommittee, important regulatory need, and if there's already been work underway, we should take advantage of that. So I would support creating it.
Councilmember Acevedo, I second those thoughts 100%. I think the amount of times justice doesn't get served in our system on either side of the aisle because somebody can't attend court as a witness or as a party because they can't lose a paycheck because they're going to lose their house if they do. It happens every day. And I think it's really worthy of seeing how the state can back some of these newly enacted protections.
Any other comments? All right, well, we will, when we vote to include that unless anybody objects.
But we do need people to see on. So does anybody want to be on it?
So, there are obviously 2 vacant spots. Is anyone interested? I'm looking at council members Tala and Acevedo, but I would open it up to anyone.
Yeah, this is Councilmember Tall. I am interested in serving on it. I would not support it without also volunteering.
Good.
This is Councilmember Acevedo. I would also be interested in assisting Councilmember Tala with those duties.
Then there were thoughts about the possibility of an automated decision-making systems and housing subcommittee. And Kevin, I don't know if you have thoughts on whether this subcommittee would, well, we have done some public hearing, public information regarding housing and automated decision systems. So I don't know if this would be.
This is Director Gish. I do have thoughts as usual. You guys are free not to follow my recommendation. My recommendation is that a subcommittee be formed to hold a public hearing on this topic to hear from experts that then could transform into a regulatory subcommittee if warranted. I think it would be interesting to hear what's happened even in the last couple of years in this space since the last time we held a hearing.
All right.
Just want to offer a comment on that. I mean, the hearing from 2021, I've now listened to that. This is Councilmember Glader, sorry. I've now watched that recording of that hearing 3 times. It was supremely helpful in just understanding the issues going into the regulatory process. So that sounds like a great approach to me.
This is Councilmember Cho. I also agree with the director's recommendation, and I'm happy to volunteer for that subcommittee.
Any other?
I would, yeah. You'll get sick of me, Rachel, but I will.
Okay, and I apologize. I've been not consistently introducing myself, but this is Rachel again. So then the last subcommittee, unless folks have other suggestions, would be the subcommittee to consider federal policy changes. What are council members' thoughts on that possible subject?
This is Yvette. I think it's absolutely imperative that we do this work to understand where the gaps are and see what options we may have to preserve what we have in California and maybe expand it to meet those, to fill those gaps.
This is Councilmember Tall. I agree, and I would be happy to serve on that subcommittee.
I would as well.
Councilmember Cho, I'm just loving the energy in this room.
Well, as I said, I'll recap everything we just discussed prior to the vote. But Chair Cho, I don't know if you wanted to open it up now for any additional council member comments or public comments.
What do you recommend procedurally?
I would maybe just ask if there are any other council member comments,
Okay.
just in case.
Councilmember Cho, are there any other comments or questions from the council members?
This is Councilmember Pena. I noticed that there isn't any work with regard to trafficking or hate crimes. And both of those things we know are happening in a disturbing degree. I also know that we have limited resources. There's only so many people to do the work. But I'm sort of wondering what the process entails to sort of put it on the on-ramp so that we don't lose sight of that.
Certainly, we do keep a list of potential future committees. So that is something, but if it's, yeah, I appreciate that suggestion. And if it's something we want to move forward with or the council feels strongly about, then feel free to make that apparent, but we can certainly flag it for an upcoming committee if that is agreeable.
And this is Director Gish. One way, so there are a couple ways that regulatory ideas come to us, and one is through department implementation, one is through legislative change, and one is through communication from advocates and stakeholders. As we sit here today, I have not personally received communications that there is a need for regulation of, for example, the Ralph Act prohibiting hate violence or the California Trafficking Victims Protection Act. That does not mean that there is not such a need. But as I sit here today, I don't know. When it comes to public hearings, I think these are two topics that can and should be explored by the Committee on Public Hearings, thinking perhaps again of the Commission on the State of Hate and its anti-hate work as a force multiplier in this space. Agree that trafficking is an area within the department's jurisdiction the council has never touched. And that might be a place where some public hearing and input would be worthwhile for the public hearing subcommittee to think about.
And to clarify, even though you're not on the public hearing subcommittee, in a meeting, like you can let the folks on the subcommittee know, like, hey, this is a topic I'd be really interested in having a hearing with, and then they can sort of.
And you can also share all of your ideas for that meeting in the public meeting.
Fair enough.
Thanks.
Indira, Cameron Banks. I think it's been clarified, but I just wanted to understand what was our role with respect to trafficking. It's full on with respect to implementing regulations, or I mean that I just didn't understand
So the department has enforcement jurisdiction over the California Trafficking Victims Protection Act, the civil action that trafficking victims can bring, or that we, the Civil Rights Department, can bring to challenge trafficking situations.
Okay, and we have not yet done we've never made implementing regulations or.
Correct.
Okay,
and as I sit here, I don't know whether advocates or practitioners believe that there is a need.
Thank you.
This is Councilmember Tala. So in the spirit of offering ideas to Public Civil Rights Hearing Committee, Subcommittee, and on the issue of trafficking, I think right now there is obviously a lot of enforcement activity around the issue of immigration, both literally boots on the ground in certain areas, but also a lot of fear and aggressive actions taken by landlords or employers that are unlawful, but taking advantage of a lot of communities' fears at this moment. So I would really encourage that to be considered as a topic. Trying to understand how people are experiencing those issues in workplaces or housing or really anywhere else, given sort of the broad mandate that we have on public hearings or civil rights hearings. So I think that would be a really cool topic to have a hearing on.
Yeah, this is Councilmember Acevedo. I 100% agree with those thoughts and those and the general feeling that I think Californians are feeling right now. And I would also challenge, I suppose, the subcommittee myself to also explore what are the limits of California authority when the federal government is going to come in and, raise the supremacy clause flag every time. And so I think that's really important right now to understand the left and right of where the state can maximize its authority, understanding that we're going to have a pretty hostile federal government every time the state tries to regulate an issue like that.
Councilmember Cho, in the spirit of also adding my 2 cents, I'll add it might be interesting to talk to some of the local human relations commissions in terms of generating ideas for public hearings. Because this came up a lot when I served on the LA City Human Relations Commission, and LA County also has a commission, and I'm sure many other jurisdictions in the state do as well. And then the second thought I had was to Councilmember Pena's idea around focusing on trafficking. I had heard in my previous work life from advocates who were very concerned about trafficking as an issue with all the global events coming to California. Not only the World Cup now, but obviously the Olympics in a couple of years. So that there might be also a very topical angle there.
Direct, go ahead.
Senior Counsel Ally Sadler. I do want to note that the council doesn't have rulemaking authority over Civil Code 52.5, which is the
Trafficking Victims Protection Act.
Trafficking Victims Protection Act.
Okay, great.
It's an interesting difference between the council's authority and the department's enforcement authority. Yeah. So with that noted, of course, you could do a public hearing on it, explore other things. Just want to flag that.
Love your lawyer.
Thank you. And Director Gish, the council does have explicit statutory authority to liaise with local human rights commissions and councils. And so that is a very appropriate statutory role for the council to play. I do encourage, and we can work with the subcommittee on public hearings to reach out to those local committees. The council also has the authority to form such committees, but I'm not really sure how that would work. And I think we've got plenty on our plate for a vote right now. So maybe we turn to that if there aren't other council member comments.
All right, Rachel, take it away.
Well, or should we do public comments? before?
Yes.
I think we need
Yes.
public comment. Can we, before we do that, could we do a run through of all, like, what we have, what the proposal is and who's going to staff?
Sure. I may repeat it again quickly before the motion, but so the proposal, the omnibus proposal, is to change existing subcommittee 11135 to focus on promulgating additional regulations. Also, there is part of the motion would be to add Councilmember Pena to serve on that subcommittee along with Councilmember Glader. Next, on the Public Civil Rights Hearings Subcommittee, there is interest in Councilmember Acevedo has stated his interest in joining the subcommittee along with Councilmember Chan. For the Contractor Non-Discrimination and Compliance Subcommittee, there is a discussion of disbanding that committee. There is adding a new committee on regulations regarding leave to attend court and other protections related to employees who are victims of violence or family members of victims. And that subcommittee would be staffed by Councilmember Tala, Councilmember Acevedo. There is another proposal to add a subcommittee on automated decision-making systems and housing. The initial purpose of this subcommittee would coordinate and hold a public hearing regarding this particular topic. And staffing that committee would be Council Members Cho and Chair Cho and Councilmember Glader. And then finally, there would be an addition of a subcommittee to consider federal policy changes, which would be staffed by Council Members Tala and Pena. So that is what we're discussing and what we're opening comment for.
Councilmember Cho, thank you, Rachel. Are there any comments from the public in person? Hearing no comments, are there any remote public comments?
Yes, Eric, please go ahead.
Yes, hi. This is Eric Anthony Devison. Again, I'm Doctor of Public Administration student and a county commissioner from Riverside County. And as you all consider the current subcommittees, I just wanted you to challenge you, this inaugural body, to kind of move past broad, safe definitions of equity and bring, I think, a deep operational lens to these specific assignments. And I'll go back to Councilmember Acevedo's speaking earlier powerfully about serving under don't ask, don't tell. So that is exactly the type of specific lived reality that needs to be to inform people how these subcommittees approach their work. So I urge each of you to consider what unique life experiences you will bring to these specific tables to uncover systemic roadblocks that the state routinely misses. So for instance, I think earlier on the slide, the Protected Employment Leaves and Responsible Accommodation Subcommittee. So that there are no vacancies there, but I urge and I challenge the assigned council members to examine chrononormativity. And that's the current bureaucratic timelines that dictate how and when individuals can access state protected leave. Our administrative systems are really built around traditional linear life cycles. So they kind of routinely punish and exclude working class people and those with non-normative life cycles or non-traditional family structures who cannot navigate complex paperwork or arbitrary timelines or time windows. And furthermore, as you all fill these vacancies today, please do not just treat them as an administrative chore. And I know you won't. I urge you to use these vacancies to intentionally position yourselves who will challenge institutional frameworks and investigate how state timelines and compliance metrics inadvertently reinforce inequities in health, employment, and public services. And I'll close with, I pray all of you will use your upcoming hearings and white papers to dig beneath the surface, interrogate the structures of California bureaucracy and build a system that works for all of us. Thank you.
Thank you for your comment. Are there any other remote public comments?
Yes, Devin Woodbine. Please go ahead.
I just wanted to say, I hope that we will also have access to some of these subcommittees to participate, submit public comments, and be able to influence any of the discussion that you guys work on. And thank you for having such a robust discussion on what you hope to see in these subcommittees and what you hope to expand. Thank you.
Thank you for your comment. Any other remote public comments?
Yes, Elle Rose.
Thank you again, Professor Rose here, and I just want to, not that you don't already have enough on your plate to deal with. I would like to urge the CRD to study the feasibility of specialized employment discrimination court departments within our state superior court system, and if appropriate, recommending legislation or other measures to advance the concept. Our courts are overburdened. I know some of you litigators know that really well. I know one court where there are thousands of cases that are waiting to be heard. Judges, we have a shortage of judges. Many people who receive a RTS, right to sue, are unable to obtain representations for reasons I know many of you already know. The attorneys can't afford to do it, etc. And as a result, many claims are never litigated. Many others end in settlement rather than actual judicial decisions. So when relatively few cases are decided on merits, there are fewer opportunities to clarify the law, fewer incentives for employers to change, etc., and less guidance for legislative improvement. So I would like to respectfully ask the council to consider assigning this issue to one of those wonderful subcommittees, maybe that public hearing one for study and recommendations. And thanks again for all of your good works and, for doing so much of this work on, I know, outside of whatever you've got already going in your work life. Thank you.
Thank you for your comment. Any other remote public comments?
Yes, RAJ.
Well, I just want to agree with everybody that's spoken and said what they said. I just want to let the legislative know that there are no trials up in Dependency Court over there in Monterey Park. Parents are not allowed to put up a defense, and what happened in 1994 is still happening today. Social workers are filing perjured petitions. Lawyers are not cross-examining the social workers, which is Ladle. Los Angeles Dependency Inc. lawyers, Children's Law Center, are not cross-examining social workers. Parents are not allowed to put up a defense. Parents are not allowed to cross-examine their accuser. They just have to stand there and get their children taken and jump through all these hoops for 9, 8, 10 years while their kids are being raped, abused, drugged without their parents' consent. So we have a lot of work to do because it's happening around the world. Majority of the vast of my parents, they haven't had a chance to cross-examine a social worker. They never even had a trial on the merits. I never even had a trial on the merits, and I can testify to that. So I think that we need to have a slam dunk hearing like in 1994 because this is happening and it's all for federal funding. They're trafficking our children for federal funding.
Thank you for your
sad. And please, 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 this is nothing that I'm making up. I can send you all my 388s that I done filed. I've wrote complaints. I've done everything I can do to save my children. And my daughter was raped, beaten, dragged under the county's position. So everybody is aware. You can Google up my name. You will find everything that I have written to the LA Board of Supervisors. And this is happening around the world. So you guys are paying these lawyers and there's no invoices. I just want y'all to know that. And I have the email to prove that the Judicial Council do not have any invoices. Thank you.
Thank you for your comment. Any other remote public comments?
Got one in here.
Oh, go ahead.
Hi, my name is Lacey Friedman, and I want to double down on what Ella Callow said. I do think that the Superior Courts don't quite see our cases through an ADA lens. And I'm definitely similar to Ms. Callow's law for parents with disabilities in the court. There are issues with children and adult children, which I'm going to speak to at the end, not being provided the opportunities they need in decision making. They don't reflect ADA, the words I was going to use. They're failing to realize that they're working with disabled children many times, not just children, but disabled children. And they're not putting forth what disabled people or disabled even adults in the nation, what we want for ADA, which is autonomy and dignity. And we can't make judges, every single judge understand ADA, but we can change statutes similar to what Ms. Callow did for disabled parents. We could do the same thing for other disabled people and my issues in family courts. So I think that's a great subcommittee, was my point.
Thank you for your comment. Any other public comment?
No.
No? Rachel, is it back to you?
Yes.
Okay.
So we're near the end of this item, but I wanted to restate all of the decisions that have been made, and these all together will be subject to a motion. So we will need a motion for the following. Changing the focus of the 11135 Guidance Subcommittee to promulgating additional regulations. And staffing that subcommittee with Councilmember Pena, as well as current subcommittee member, Councilmember Glader. Next, the proposal is to add Councilmember Acevedo to serve with Councilmember Chan on the Public Civil Rights Hearing Subcommittee. The next proposal is to disband the Subcommittee on Contractor Non-Discrimination and Compliance. The next proposal is to create a subcommittee on regulations regarding leave to attend court and leave and other protections for victims of violence and family members of victims. And that committee would be staffed by Council members Tala and Acevedo. The next proposal is to create a subcommittee on automated decision-making systems and housing. And the purpose of this subcommittee would be to hold a public hearing on this issue. That subcommittee would be staffed by council members Chair Cho and Council Member Glader. And then finally, the last proposal is to add a subcommittee to consider federal policy changes, which would be staffed by council members Tala and Pena.
I move.
Second.
Okay, Councilmember Pena moving, and that motion has been seconded by Councilmember Glader. And then do we vote now? Okay, and I will pass this to Ally.
Yes, I will do the roll call. Okay, Chair Cho.
Yes, aye. Which is what?
Either will work.
Okay.
Yes or aye in support of the motion. Councilmember Acevedo.
Yes.
Councilmember Cameron Banks.
Yes.
Councilmember Chan.
Aye.
Councilmember Glader.
Aye.
Councilmember Pena.
Aye.
Councilmember Tala.
Aye. And the motion carries. I will work on this for the next meeting. Okay, thank you so much, Rachel. We are now on to agenda item number 12, further public comment. We will now hear public comment on items that are not on the agenda. Please note that the council may not discuss or act on any matter raised during the public comment section that is not already included on this agenda, except regarding whether the matter commented upon shall be placed on the agenda of a future meeting. Do we have any council member comments? Hearing none. Do we have any comments from the public in person?
Once again, last time. So I'm Lacey Friedman, and I will be speaking about this. Now, we've already brought the issue up in terms of a subcommittee on taking a look at legislation. So I wanted to let you know that I spearheaded AB 2397. So, which Congressman Mainshine and the ARC assisted with that. And the impetus of that bill was that people, disabled adults in family court, would retain their Title 16 SSI and also be able to get additional resources through familial support and not lose their SSI by utilizing a trust. The idea was through that, they would have a more dignified life. They wouldn't just have their SSI. They have additional funds that were due to them. The court in California allows disabled child support. Well, I will say that my law is not working. And I've spoken to people around the nation and in the state, and because courts don't understand public benefits and they don't understand what a disabled person really needs to live comfortably, and they don't understand the difference between what a child support is for a child versus a person that's going to have child support their entire life and has needs that are very different. I think that Ms. Callow's law protects disabled parents in family court. Nothing really protects disabled children in family court in terms of civil rights. So the California Law Revision Commission 29 years ago made recommendations to change these laws, and nothing's happened. We are not a forerunner. Many other states protect disabled people in family court, disabled adult children, much more so than California. I've been studying this for 4 and 5 years. I've spoken to Ms. Callow, I've spoken to Sarah Lore, I've spoken to everybody around the nation. And I think that we really need to be looking at how disabled adults, specifically I'm saying in family court, how they can be protected with statutes. Because that's it. I got 1 minute.
You have 1 minute left.
Oh, clear. Thought I only had 1 minute when you held that up last time. So again, the Law Revision Commission also recommended the same thing. I just don't think they understand, courts don't understand an ADA lens. There's an article called Unaccommodated that says how courts will send people to a federal court or don't understand, they don't want the ADA to mess up their rule. And in my case, the poster child lost his SSI. So my son, the court made a direct ruling that made my son lose his SSI and said that that was not their problem, that their problem was family court. And so I'm not the only one this has happened to. Again, that's why I'm been an advocate since Partners in Policymaking that I took with, what's his name, Justin? Anyway, with the head of the ARC 20 years ago. So I'm very interested in promoting the rights of people in court.
Thank you for your comment. Are there any remote public comments?
Yes. Devin, please go ahead.
Hello. I had spoken earlier about my CCRD case for housing issue that came from HUD. I know you guys have talked a lot about the federal piece, and what makes California unique is HUD has determined that we have the robust laws and the resources to deal with investigating complaints of whether it's discrimination, harassment, retaliation. And HUD took my complaint with the evidence that I had and made a determination that my housing provider did engage in some form of discrimination. And my other claims, well, I was supposed to happen where CCRD was to look into source of income, age discrimination. And when CCRD was supposed to do that, they refused to take any of the evidence, speak to my witnesses, and it got closed out. I now have a deadline of September to go and pursue an action against the owner, but as low-income residents, we don't have that. I've been, working hard to get responses, and I've had my representatives from Lola Smallwood's office, Sade El-Harari's reach out, and it's been radio silent. And I know you guys aren't able to take action on that, but if you guys are going to get reports from CCRD, they also need to be transparent about why they're not enforcing federal legislation and the state laws that exist for when a tenant or an individual comes with a complaint and has the evidence to meet the statute, and in some cases they're exceeding it. So I hope you guys push back on some of those narratives and really clue in that a lot of times we have people who are filing complaints with evidence that CCRD is not applying the applicable law, or they're closing out cases because maybe they don't want to pick it up. Thank you.
Thank you for your comment. Any other public comments? Remote?
Yes. R.A. Jace. Please go ahead.
Yes, hi. Yes, he's absolutely correct. Like they're throwing away our complaints with evidence. They're not investigating. Really, nobody cares about ADA, especially in the courts, dependency law, family law. Everybody, they don't let them come into court to support the disabled people. I had even a struggle just to trying to record my court hearing because I needed to understand what everything that actually happened. So we are just left, just like the domestic violence people, we're just left to defend ourselves in these courts against our abusers and our accusers, while we're having panic attacks and, all those certain things going on. But I filed, like I said, a civil rights complaint 11/21/2025, due to all these violations, me being screamed at. I was retaliated against. My CalWorks and CalFresh was going up and down, and then they cut my son's Medi-Cal off the day of his surgery. My 3-year-old, he's supposed to have a surgery for hernia, and because I filed that civil rights complaint against Mr. Dumas over there on Adams and Grand because he was screaming at me and refused to log me in to handle my business, I came respectful. I wasn't disrespectful to anybody. Before he took me, he took a Mexican lady. He didn't scream at her or anything, but when it came to me, it was just like a demon that jumped in him. Once I started reading him the laws and I asked him for a special payment or something that was on the form, and he said it wasn't on there, and I said, I'm reading it. So what are you talking about? And then, it's just very nasty, and nobody cares about ADA. Going into the courts act oblivious and dumbfounded, when we have these people coming in to support us. They want us to come in by ourselves so that they can rape, abuse us, and violate our due process and civil rights. And this is serious. This is not a laughing matter. because civil rights are being violated every day, and even children. They are not, even children. So this is not something to laugh at. This is something to investigate. This is something to look at in the 1994 Legislative Digest, because this is the people, and you guys are going to be running the show, so I just, want you guys to take it serious, because these are people's lives, and this is what's happening. You guys have to pick up all the stuff that the previous person may have, not done. And it's a lot of work, but rights are rights, and clearly nobody in the courts cares about rights, because it's a lot of corruption. Thank you.
Elle Rose.
Thank you. Once again, I just want to encourage you folks, as you are writing new possible legislation or rules, to really keep in mind the big picture. Is it really going to be enforceable? Is someone really going to be able to bring this into a court, for example, and have this actually adjudicated? I really, really want to urge you to keep the bigger picture in mind as you go forth. Thank you.
Thank you for your comment.
Just emails left?
Yes. We have 2 public comments via email. The first is from Zella Knight, a lived experience activist, regarding data collection, responsiveness, and the fair housing complaint process. I will read until I reach 3 minutes. If I don't finish, please know that the rest of the email will be shared with the council in full.
Also, you can summarize.
Okay, I will summarize. So the comment expresses concerns regarding the current collection, tracking, and reporting of tenant and residential complaints, particularly those involving potential fair housing violations and discriminatory housing practices. The suggestions that Ms. Knight discusses are standardized data collection, improved responsiveness and accountability, public transparency, equitable access to the complaint process, and independent oversight and continuous improvement. So those will be shared in full. That email will be shared in full with the council. The other commenter is Anna Raquel Pines the first. Ms. Pines states that that their civil rights are being violated by the HOA. They are a person with autism and a developmental delay, and are experiencing civil rights violations by her HOA. They would like to call in or would have liked to call in today, but I don't believe we heard from them. So I'm sharing the email and we'll share it in full with the council.
There's 2 more. There's RWA.
Oh. And as I mentioned before, a couple of commenters who commented remotely today also submitted emails, and that includes, excuse me. Just a moment. That includes Renisha Hubbard, as well as Kai An. And otherwise, there are no further comments via email.
Councilmember Cho, thank you, Rachel. And now on to our last agenda item, adjournment. This concludes our meeting. This meeting is adjourned at 2:44 p.m. Thank you.